Hello, everyone, and welcome to another edition of Mormon Stories Podcast. I'm your host, John DeLynn. It is Wednesday, September 25th, 2024, and today we are covering the Huntsman tithing lawsuit. Today, I won't get the legal jargon right, but today, James Huntsman and his legal crew will be appearing, I believe, in a San Francisco courtroom. I believe it is courtroom 1 in the James R. Browning U.S. Courthouse in the United States Court of Appeals for the Ninth Circuit, where James Huntsman will be arguing the merits of his case, suing the Mormon Church for fraud. Now, this is a crazy week in Mormon Stories history, because there was another hearing on Monday that we covered where in Denver there was a hearing reviewing the credibility of the Gaddy case, where the Mormon Church is being sued for history fraud. And today we're going to be again talking about the Huntsman case, which is a totally different type of fraud. And because I don't know my backside from a legal book, we have with us today Kolby Reddish, our resident legal expert, to help us understand what's going on. And basically, we're going to be, Kolby's going to share with us some context. And then at 3:30 Mountain Time today, we're going to just tune in to the hearing. We're going to listen to it live, and then we're going to react to it afterwards. And of course, we're live streaming, so we've got Maven and Julia behind the scenes. They're going to star the best comments and the best questions, and then we're going to do our best to allow you to share your thoughts and feelings and to ask questions of Kolby. And of course, we thank our monthly donors to Mormon Stories, the Open Stories Foundation, that make all this possible. Please go to mormonstories.org, click on the donate button, become a monthly donor if you value this content and want to see it continue. But please, if you're already a donor, know that we couldn't do this without you. We also always welcome super chats, which are donations through this live chat on YouTube. If you want to make sure your question or comment are seen and shared, we invite you to do it through super chat. And of course, the money in the super chat will go to paying our staff and our operational expenses. Finally, we always appreciate it when you subscribe to our YouTube channel and like it. And also know that tomorrow, September 26th, we're going to be running a live stream, sort of a global vigil in support of Nemo the Mormon, who is set to be excommunicated tomorrow. So please plan on tuning in tomorrow and showing your support. I've reached out to a lot of excommunicated Mormons to appear on the show, and we'd love any of you who want to show your support to Nemo to be there as well.
Perfect.
Okay.
Well, I will just give people a quick roadmap of what we're going to cover today, in addition to the introductory comments that John's already made. We are going to cover the oral arguments live. That's why I wore my favorite suit and one of my favorite ties, because I love going to court. It's one of the things I like the most about being an attorney. So we are going to talk about the basis for the Huntsman lawsuit. We're going to talk about the previous procedural history of the case that got us to where we're at for the oral arguments today. And then we're going to talk about some of the substance of the case after the fact. And we'll also talk about some interesting tidbits that I found last night looking at amicus curiae that are joining the church's position. At a high level, as a reminder for our viewers, in a legal sense, this case is about financial fraud, and specifically financial fraud. James Huntsman, the plaintiff, is alleging that the church committed financial fraud when it solicited tithing donations, specifically because it made certain promises, at least according to Huntsman's theory of the case, that it made specific promises about ways it wouldn't use tithing funds to go towards completion of the City Creek Mall project in the early 2000s. And so at a high level, I guess one of the things I wanted to start off reminding people is that fraud, or financial fraud, is in a legal sense to knowingly make a false statement to induce another person to rely on it. So that's the basis of Huntsman's allegation, is that the church made certain statements that were false, that time has basically proven to be false, that induced Huntsman as well as other members tithing donations, and that if they had known the truth, they would not have made those tithing donations. And so one of the ways I kind of conceive of this is that it's basically making a statement or adding some condition that is false or misleading. And so the basis for the Huntsman claim is 5 statements that Huntsman claims the church made that were misleading, specifically with regard to the use of tithing funds going towards City Creek. So if you can go back one slide real quick, John.
This one?
Yep. I just wanted to, again, remind people we have 3 different cases that basically involve similar allegations. On Monday, we talked about the Gaddy case, so people can listen to that live stream if they want. Today, we're going to talk about the middle case here, the Huntsman oral argument, which is set for an en banc rehearing today at the Ninth Circuit after the case was dismissed by the trial court and then reinstated by the first appellate panel, finding that Huntsman did have or did allege sufficient facts to present his case ultimately to a jury. So that's one piece I guess I wanted to start with, just to make clear. When we're talking about appeals, I talked on Monday about how appeals are a very specific set of practice of the law. It's a subset of practice of the law that involves, complex legal questions oftentimes. And so when you have a case like that, you can rarely have a situation where a district court's decision is reversed, as happened in Huntsman's case. And then even rarer still, you can have a case where one side of the dispute asks for the entire Ninth Circuit panel to grant what's called an en banc rehearing. And that's where the chief judge of that circuit, as well as 10 randomly selected judges, will sit and rehear the case. And part of the reason for that is because the original panel decision was closely divided. It was 2-1. So that means ultimately two federal judges have sided with Huntsman and 2 federal judges have sided with the church. The third case that we talked about on Monday, just briefly, is there's also district court litigation that started in the District of Utah in front of Judge Robert Shelby that involves very similar claims to James Huntsman's. So James Huntsman's case only involves James Huntsman's claim that the church defrauded him in soliciting tithing donations. And I guess that's important for people to keep in mind, is that Huntsman is claiming $5 million in tithing that he feels was fraudulently gotten from him. But one of the things we know about the legal field is that oftentimes we have test cases like Huntsman's that then can create breakoffs in the law or create new areas where the law can develop, and that's the Chappelle case. So one of the first things I wanted to do, because I get questions like this every time we do one of these podcasts together and talk about these tithing cases, is I get questions from people, including at work, about, how do I join these class action cases? The Chappelle case is seeking class certification here soon. And so the first thing I wanted to start with is, if you're interested in this issue, I promise that eventually we'll be able to give you more direction on how to join the class in the Chappelle case as it moves forward, if it moves forward. But for right now, we just need to be patient. There's no way to join the class right now because no class certification process has even started. So there's going to be some filings that go back and forth in front of Judge Shelby in the Chappelle matter. As long as John will continue to have me, I'll continue to come and keep people apprised of how they can join that class when and if that happens. So that's the first thing I wanted to get out of the way. The second thing is I wanted to note, based on some feedback I received from a believing member, which I really appreciate, from Monday's episode in the comment section, they had asked me why, when I'm talking about the statements that individuals like Huntsman or Gaddy or in the Chappelle litigation, when I'm talking about various statements that church leaders have made, specifically on Monday, I was talking about a statement that Gordon Hinckley made in April 2003. This believing member was asking me why, when I'm talking about these statements, do I always take the most cynical read of those statements? And one of the things that I wanted to explain, that I did explain in the comments to this individual, but it was a very good note because I want to address this, is it's very important for people to understand that at this stage in a litigation, that the plaintiffs, meaning James Huntsman and Gaddy as well as Chappelle, they are entitled to every favorable inference of fact. The idea is these cases were resolved at the district court level on either motions to dismiss or motions for summary judgment from the church. So those in the legal field are what are known as dispositive motions. They're motions that dispose of a case. At a layperson level, It's basically me saying to John that, someone has wronged me, and that person coming to John and saying, I admit that I did what Kolby said, but what I did wasn't wrong. And so that's one of the reasons at just a basic level that I'm reading those statements in that way. It doesn't have to do with any bias I have against the church or the fact that I'm an ex-Mormon. It has to do with the fact that the law requires that the plaintiffs, who, like every other party, are entitled to have their day in court so long as they've stated a claim upon which relief can be granted, that they have the right to offer their case to a jury ultimately, as long as the church's arguments on these motions to dismiss are not recognized. So I wanted to address that comment head on, and just make clear that as a matter of appellate law, when we're talking about appeals, that's where I'm coming from. And I should have been more clear about that on Monday. But I wanted people to know that especially when we talk about the statements from President Hinckley and other church leaders towards the end of our stream today, that's why we're looking at them in that way, because that's what the law requires. So Julia, if you'll go to the next case, or the next slide for me. Okay, perfect. So this is to get people acquainted, if they haven't heard already, about the theory of Huntsman's lawsuit. So James Huntsman is a member of, or was a member of, the LDS Church, and he contends that the church made various false statements about the nature of funds used in the City Creek Mall commercial project, while it solicited tithing donations from him in the amount of $5 million. So that is ultimately the amount he's seeking to reclaim from the church. I know that someone had asked about that in the comments. That is publicly known. Huntsman ultimately contends that the statements the church made, in particular one from Gordon B. Hinckley in 2003, are false according to leaks that came to light from Ensign Peak insider David Nielsen, and that in essence, the church used tithing funds to build City Creek Mall when it said that it would not. The church contends that it did not mislead anyone based on reading each statement in a particular light. The church also argues that the case itself, like just bringing a case questioning tithing donations or conditions on tithing donations, violates the First Amendment's protections of religious freedom and the Establishment Clause and the Free Exercise Clause. And I just wanted to note on that particular argument that no judge, including the two who at the district court level and then on the first appellate panel ultimately found for the church, have agreed with that argument. So all four judges who have heard this case have said that this case does not implicate the First Amendment. That's one of the delineating factors we talked about on Monday that I see between this case, and one of the reasons I think this case has a much greater chance to succeed than the Gaddy case, is because the Gaddy case does involve some claims that arguably fall within the scope of the First Amendment, while this case, no judge has agreed with the church's position on that this case implicates the First Amendment.
So if you go after a church for teaching false things or misrepresenting its history, that's sketchy ground. You're treading on First Amendment territory, and judges are going to be inclined to not mess in that area. But if you're alleging pure financial fraud, totally disconnected from truth claims or history or beliefs, you're on much safer legal territory. Is that right?
That's exactly right, John. That's
Okay.
exactly right.
Okay.
The idea, again, that we talked about on Monday is if the claim that you're bringing is the same type of claim that you could be bringing against any other secular institution, like an institution that could be a religion, but also could be any other type of claim, then you're probably safe from a First Amendment perspective. And that's one of the great things about Huntsman's case. So procedurally, just a few minutes before we start with the oral argument, Julia, will you go to the procedural slide? Perfect. So as I said, Huntsman's case was originally dismissed by the trial court judge. It started in the District of California, so in a California federal district court. And Huntsman appealed that decision to the Ninth Circuit. As we talked about, he won in a 2-to-1 decision from the panel, finding that when the statements that we're going to talk about towards the end of our stream today were read in the light most favorable to Huntsman, the church could have been found by a reasonable jury to have committed fraud. And so that's, again, one note about appellate procedure that I wanted to make sure our viewers understand, is if Huntsman wins today's oral argument, and oral arguments are not decided the day that they're argued, the court will take the matter under advisement and likely render a decision in a few months. But if Huntsman ultimately prevails, it does not mean that the LDS Church committed fraud. It means that James Huntsman has the opportunity to offer his case to a jury to make that case. That's what's being determined today, is basically under the law as it stands, has he stated a claim that he has the opportunity to present to a jury? Now, the church requested an en banc rehearing, which is very rarely granted, and the Ninth Circuit granted the church's request. And so the matter today will be heard in front of 11 judges of the Ninth Circuit Court of Appeals.
So help me understand, if 3 judges in the Ninth Circuit, overturned the original judge's ruling, how do they get another shot at 9 judges? Is that just part of the legal process? It's just part of the appeal?
Yeah, it's part of the appellate process, and it's actually a great question from like a history of the judiciary perspective, John, because the only federal court that's really required to exist by operation of the federal Constitution is the Supreme Court of the United States. The rest of the federal system is created by federal statute, and so it's a right that arises by operation of the federal statutes that govern appellate procedure.
Kolby, really quick, we have a question in the form of a super chat. Ryan writes, couldn't you say other companies make truth claims that can be disputed? And they reference essential oils, herbal medicine, other sorts of things. Anything you want to say about that?
Yeah, I guess I'd say that if you want to start an herbal medicine, an essential oils or herbal medicine company that you feel like may run aground of fraud cases, maybe you should incorporate it as a religion. I guess that's the only thing I'd say. Yeah, and it's one of the things that's complicating about this case, because we do have this recognition in the First Amendment that, especially in America, that religion has this, I would call it a privileged position. Other people would call it religious freedom. Regardless of what you call it, the bottom line is that for incorporated religions, the rules simply are different. And that's where, we talked on Monday in detail about the church autonomy doctrine and why I think that policy actually is sound, that churches and religion should have the ability to set the rules inside of their own congregation in matters of, their internal procedure and rules. I may disagree with those rules, but I think just as a matter of the way the First Amendment works, that they do have that right. If people wanted additional detail on the actual decision, the original panel decision that reversed the district court's dismissal, we did discuss this on an episode of Mormon Stories 1796 with Radio Free Mormon, Rebecca Biblioteca, and myself. So if people want to listen to that, they can get additional background on that decision. We actually walked through every single line of it and have multiple discussions about it. I wanted to highlight just a few relevant facts in the panel's decision to give people the context if they haven't listened to that past episode. And I know it's been about a year since we did that anyways, but one of the relevant facts in the panel's decision I think is very important is this David Nielsen affidavit. For people who don't know, David Nielsen is the Ensign Peak whistleblower whose report was leaked, I believe, to the Washington Post in late 2019. And this is a direct quote from David Nielsen's affidavit in the panel's decision, again, that led ultimately to where we're at today. He stated, quote, during my employment at Ensign Peak Advisors, EPA's senior leadership and other EPA employees referred to all funds of EPA as tithing money, regardless of whether they were referring to principal or earnings on that principal. In addition, during my time at EPA, tithing donations from the church's members were commingled with earnings that Ensign Peak had made. And the reason that this is very important is because, as we'll see, and hopefully they'll discuss at oral argument, there's one statement in particular from Gordon Hinckley in April 2003, where the church is really trying to create this separation between tithing donations and invested reserve funds, which also came from tithing. And so David Nielsen's affidavit is basically one of the biggest reasons that this case is, if it ultimately heads to a jury, I would say that fact alone is one of the biggest reasons for that.
I don't want to steal your thunder, but if I remember right, also they talked about explicitly at Ensign Peak, David Nielsen reports that that there was explicit intent expressed to hide the amount of money and the existence of this money for fear that members would pay less tithing. And maybe there's a slide you're going to talk about that. Is that right, Kolby?
That is the very next slide. But John,
I'm so sorry.
You can steal my thunder anytime. It is your show.
Go for it, Kolby.
So this is right from the panel's decision last year. Nielsen further affirmed that at a 2013 meeting, Ensign Peak's president, Roger Clark, advised of 2 withdrawals from Ensign Peak. One was for $1.4 billion over 5 years to fund City Creek. At the presentation, Nielsen asked Clark how the church's public statements about no tithing funds being used for City Creek Mall or Beneficial Life could be consistent with the withdrawals for those projects. According to Nielsen, Clark answered that funds for the City Creek Mall project were transferred from Ensign Peak to Property Reserve in order to conceal the source of the funds. So that right there is that intentionality piece that you're talking about, John. Mr. Clark responded that two other church-affiliated entities, Property Reserve and Deseret Management, had received from Ensign Peak the $1.4 billion and $600 million, respectively, paid by Ensign Peak for City Creek Mall and Beneficial Life, and essentially that, as a result, people would not know that Ensign Peak was the source of this funding to City Creek Mall and Beneficial Life. Mr. Clark stated that it was important that people should not know Ensign Peak's role as the source of the funds. One of the things I also wanted to highlight, I don't have this on a slide, but the church also filed two declarations that did not contest this. So Roger Clark himself actually filed his own declaration that did not contest, even though he could have, right? He knows what he said. He could have said, I didn't say what David Nielsen says. And the panel decision from last year actually draws attention to that to basically say he could have contested this and didn't. And one of the things that we know as a result of the SEC order that Ensign Peak was involved in last year, I think it was in February 2023, the church entered into a stipulated settlement with the Securities and Exchange Commission. We know now that Ensign Peak was created with $7 billion in excess tithing in 1997. And we know that its manager, Roger Clark, and the church's senior leadership were so involved in starting it and taking such extreme measures to keep the entire thing confidential that they ultimately admitted to violating federal securities law for over 2 decades. And that resulted in the imposition of a $5 million fine, which the church agreed to. It's important to note that of that $5 million, $1 million was imposed directly on the church. Like the church had to pay that directly from its own accounts. And that was because of senior church leadership's knowledge of, involvement in, and approval of the practices of creating shell companies that did not actually have control of the assets that federal forms that they filed said they were managing.
And again, I think one of David's biggest concerns was both for his own tithe paying, but also on behalf of the membership, that he nor did he think the members had any idea that all this tithing money they'd be paying, instead of going to legitimate charitable uses, would instead be going to bail out a luxury shopping mall and a failed insurance company. Is that correct?
Yeah, that's exactly right.
Yeah.
The one last little note I would say as we head into the oral argument here in about 5 minutes is one of the things that was slightly irregular about this case. And maybe we'll see a focus on it in an oral argument. It's kind of exciting because we don't know. The panel actually sent the parties notice just a few weeks ago, which is kind of irregular, that they wanted the parties to be prepared to address the issue of Huntsman's residency at oral argument. If you'll go to the next slide, John, I think I've got it. Yeah, perfect. So the reason that the court is asking for Huntsman and the church to be prepared to address this is because federal courts are courts of limited jurisdiction. So when you asked earlier, John, about, why does the en banc rehearing work the way it does, it's because we have statutes that govern the federal judiciary. And the federal courts are only able to hear certain types of cases. At a high level, the types of cases they are able to hear are either cases that involve federal claims, so some federal statute, or to hear claims between citizens of different states. That's what's known in the legal field as diversity jurisdiction. So for Huntsman's claims to have been properly brought in California and the Ninth Circuit rather than in Utah and the 10th Circuit, he must have been a resident of California and not a resident of Utah. And the reason is because he's not alleging any violation of federal law by the church, only violations of California's state statute and some common law causes. And so I was just going to say what that means is if the court ultimately finds that Huntsman was a resident of Utah, as disappointing as this would be, it means that it cannot consider the merits of the parties' positions at all. So if we hear a lot of questions about that, and it seems like it's not going Huntsman's way, what that means is that the federal court does not even have the jurisdiction, the subject matter jurisdiction, to consider the case. They will dismiss the case as being improperly brought, and that's likely what they'll do if they ultimately determine that Huntsman was not a resident of California at the relevant time period.
And I can just say I've been a friend of James Huntsman for many, many years. And I know for a fact that he moved to California, as I understand, sold his house, moved to, the San Diego area and lived there, and was living there when he filed this case. So that's my understanding. I have personal, connections there. And unless there's some technicality that I'm unaware of, there should be no legitimate question to his California residency.
Oh, that's interesting. Since you're friends with him, that's interesting to hear. The reality of that test, it's a test that's known as the domicile test, is it does have some weird subjective elements, but for most people, it's fairly easy to determine where they live, right? Like I've lived in Idaho for the past 10 plus years, and unless I had some intention of moving, that's one of the ways that basically the test can get a little bit more complicated.
Yeah.
So that kind of sets the frame for what we expect to see. It'll be really interesting to me to see how many questions we see from the panel, whether the questions focus on that issue of subject matter jurisdiction we just talked about, or if they get right to the merits of the case. I think it'll be really interesting to see ultimately how it evolves.
All right. Well, let's go ahead and add the hearing. It's gone live. They haven't started yet, but now it is there. We'll come back. We'll just let the viewers and listeners know we're going to come back and allow Kolby to do some further insight after the hearing begins. But Kolby, really quickly, we've got a couple super chats. Susie Catherine basically said, keep up the good work. They aren't going to get my money. Thank you, Susie, for that super chat. Son of Perdition asks you, Kolby, do you think this would lead to laws restricting churches from telling false narratives?
Yeah, we talked about that a little bit on Monday. On Monday's oral argument, the attorney for the church essentially argued there's no limit to the misstatements that a church can make. It basically can't be held to account for any statement it makes about its history. And I used this phrase on Monday. I'll use it again today. There's this notion sometimes in the law that pigs get fat and hogs get slaughtered. When I say the law, I just mean it's a concept that we see sometimes where these pendulums swing back and forth. And so ultimately, if that is the result, that basically the church can say whatever it wants, and it can't be held to account of it, and that's what the First Amendment means, you may see some shift against that in the court of public opinion. And ultimately, that's what leads to legislation and potential amendment of the Constitution, even if necessary.
All right. Well, here's the view inside the courtroom. It's literally 3:30. I can hear the audio coming online. So this is kind of fun, Kolby, to be doing a live broadcasted analysis. How do you feel?
I feel great. I think next time we need to coordinate tan suits, John.
I know I'm sloppily dressed. It's my fault. I'm feeling overworked right now, so I just came in shorts and sandals, but it's not appropriate courtroom attire. Fortunately, the judge won't be seeing me. So that's kind of fun. It would be kind of fun to actually travel to San Francisco to be there live, but we've just got too much going on, including, again, Nemo's excommunication tomorrow. All right, here it is. The judges now the judges are now rolling in. Any analysis, anything that's interesting of note, Kolby?
You'll see the weird, antiquated formality of the way we still do the court system. I find it interesting.
The United States Court of Appeals for the Ninth Circuit is now in session.
Thank you. You may be seated.
Wow. So many judges.
Good afternoon and welcome to all of you. Welcome to the James Browning Courthouse here in San Francisco. We're all happy to be here. This is the time set for the case of James Huntsman versus the Corporation of the President of the Church of Jesus Christ of Latter-day Saints. If the lawyers are ready to proceed, you may come forward.
This is the Chief Judge of the Ninth Circuit, John, Mary Murgia.
Good afternoons, and may it please the court, your honors. My name is David Janellis, and I represent appellant James Huntsman. Before I begin, may I reserve 5 minutes for rebuttal? Thank you. I'd like to start, Your Honors, with a quote from a song that I'm sure you all know. When I find myself in times of trouble, Mother Mary comes to me, speaking words of wisdom, let it be. In most contexts, the name Mother Mary has religious connotations. But here, it's just Sir Paul McCartney singing about his mother, Mary McCartney. It's secular. And the same is true of the word tithing, Your Honors. In many cases, that word would invoke religion. But here, in this Nero case, the implications are no more religious than the song Let It Be.
Counsel, how can you say that? I understand the importance of avoiding constitutional questions where we don't need to do that. But for example, the Supreme Court in Presbyterian Church versus Mary Elizabeth Blue Hull that dealt with a trespass claim, Our Lady of Guadalupe, which dealt with an employment claim, and Kedra versus St. Nicholas Cathedral of Russian Orthodox Church dealt with an incorrect incorporation of secular legal principles to church governance. Why in this case, where we're dealing with tithing, which, if you would agree, is a very common principle among many, many religions. You've seen some of the arguments from the opposing counsel, or actually more the amicus counsel, talking about the many differences that there are among religions about the meaning of tithing. But to my understanding, tithing, unlike your Mother Mary example, is a quintessential religious issue. In fact, I don't know of any use of the term tithing that is not religious in context. What am I missing?
Your Honor, you've cited 3 cases in which the church's decision-making functions were at issue. For example, in Our Lady of Guadalupe School, as Your Honor noted, that had to do with a decision to hire or fire. It was employment, which is why the ministerial exception applies. What we have here is more similar, Your Honor, to U.S. v. Rashid, where in this circuit found that even where, and there it wasn't called tithing, but it was still a donation made to the religious organization under a supposed commandment of God, and the organization in that particular instance had not disclosed how the money was being used truthfully. And this circuit found that it doesn't matter that the concept of donation may be cloaked in religion. That's not a way to get away from fraud. And Your Honor, this is a fraud case, a simple fraud case for which the First Amendment provides no sanctuary. And frankly, that's why every single judge that's looked at this case so far has reached the same conclusion with respect to the First Amendment, even where they may have staunchly disagreed on other issues. And to this point, Your Honors, I'd like to spend my limited time here today addressing 3 points. First, the secular nature of this dispute. Second, inferences that must be drawn in Mr. Huntsman's favor. And third, the slippery slope. And I also understand that the panel has requested that we be prepared to discuss domicile. And should the panel have questions, I'm happy to address them.
Counsel, you may be going to address this, but I hope you will. Your claim sounds under California tort law for fraud. And one of the elements of that, of course, you know, is justifiable reliance. I'd be interested to know, wouldn't you be asking a jury to determine whether Mr. Huntsman's reliance was justifiable? And in order to do that, wouldn't you have to understand what a reasonable church member would know, which would get you into the religious context? Would you, at some point, will you answer that question, please?
I'm happy, Judge Smith, to answer that question now. With respect to the issue of reliance, and again, this gets me to preview my second issue of inferences, we have Mr. Huntsman's sworn testimony on pages 44 to 45 of the record, unequivocally that he relied on the church's statement that the money for City Creek was coming from somewhere other than tithing. In fact, the church on one instance at least went so far as to say not 1 penny of tithing was used. And Mr. Huntsman has stated unequivocally that that mattered to him, it was material, and that impacted his decision to donate tithing.
It still has to be reasonable reliance, right? That's the test under state law. So he may subjectively believe that, but we would then have to ask, or a jury would have to ask, is that reasonable?
That's correct, Your Honor. And
Right,
again,
then at that point, sorry to cut you off, but the question would be, How is that not essentially weighing his belief that he gave tithed monies as a condition for something, and the church's view that tithe money is a required commandment?
Because, Your Honor, in the context of the reliance here, Judge Bress, it's a secular issue. It's one of accounting. And that's the fundamental way we would submit that this case has been misframed by the church, respectfully. Yes, tithing is a religious doctrine, a commandment from God, as the church would have it be known. However, to address tithing in the context of this case, with the facts at bar, we don't need to look at any commandment. We need to look at the church's own secular definition of tithing, which at the record at 682.
And just to pause you, how can a church have a secular definition of a religious obligation? I don't understand how that could be.
Because it's not about the reasons for giving tithing in general. It's the reasons for giving the tithing in this particular instance. Again, it's a very—
Well, counsel, let me follow up on that, because I'm really struggling to understand how this case would be tried without really delving into not only the church's view of what its doctrines dictate, but Mr. Huntsman's own understanding of tithing and how tithing donations would be utilized. I thought that he had testified at numerous points in his declaration, talking about how when he gave the tithing money, there were no conditions put on it. And the reason was that as a longtime church member, he had a very firm understanding of what tithing really meant. And all of that understanding really stemmed from church doctrine, or his understanding of church doctrine. So I take it that your argument really tries to narrow the trial on the few statements that were at issue in this case. But if this case were to go to trial, wouldn't the church be entitled to pull the lens back and talk about tithing, the purposes of tithing in general? They would be able to talk about President Hinckley's statements, not just as narrowly defined as you, but much broader than that. And in response, then Mr. Huntsman would also potentially testify about his own understanding of religious doctrine. I just don't see how this case could be tried as narrowly as you're contemplating. Can you respond to that?
Of course, Your Honor. And this goes to Judge Bress's question as well.
Yes,
and to your
I'm
question,
really
Judge
struggling
Wynn.
with the same area that his questions went to.
I think we need to respectfully back up for a moment just to talk about this case, because you've referenced what the case is about. And let me be clear, lest this has been misframed by the church. Mr. Huntsman in this case does not challenge how the church ultimately chooses to spend its tithing, even if it spends the money on City Creek or on Beneficial Life. That's the church's prerogative. That's protected, admittedly, under the First Amendment and 14th Amendment, the autonomy doctrine, whatever we want to call it, and completely distinct from the issue here. The issue here is how the church told Mr. Huntsman under its definition of tithing, which again is not secular. The church has used general accounting principles to describe the tithing here. If we look at page 682 of the record, the church has stated that tithing, as President Hinckley apparently understood it in 2003 during his general address, was the principle, the money that my client, Mr. Huntsman, took and gave to the church before it was invested anywhere else. It wasn't.
Does it matter that the April 2003 speech came from President Hinckley in this religious context? In other words, this wasn't just any old speech. It was given in this broader sense of describing the church activities and religious mission. And isn't there a concern if you're asking courts to start parsing these speeches, whether it's going to chill something within religious doctrine or internal church or governance, that a church leader might have to run a speech by legal before he can deliver a sermon?
No, Your Honor, and respect to that actually piggybacks very nicely on Judge Bress and Judge Wynn's question. I can answer all these together because the answer would be no more so than the religious statements made in Rashid, no more so than the religious statements made in Maktab Tariq or in Animalai or in any of the other cases where our Supreme Court or this circuit or other circuits such as the 11th Circuit in Animalai, or the Court of Appeal in Texas in Libhart have addressed issues where in the context of a sermon, for example, in Rashid, Pastor Rashid told his congregants, it is God's will from the pulpit that you give your money as ministers, and it will be quadrupled under the will of God. In that case, just as we would submit in this case, Pastor Rashid knew at the time that he made that statement that it was not actually going to be quadrupled under the will of God. It was going to be quadrupled by all of the other donations that were taken in what this circuit characterized as a pyramid or Ponzi scheme. In this case, likewise, there is at a bare minimum, Your Honors, a triable issue of fact as to when President Hinckley and Bishop Burton and the church's official magazine and the church's statement to Deseret News and Keith B. McMullen's statement to the Salt Lake Tribune at the time that all of those statements were made
About McMullen, don't we have to decide whether or not McMullen can speak for the church? And isn't that a religious question?
No, Your Honor, because at the time that McMullen made the statement, he was speaking on behalf of the church, and he said that not one penny of tithing was being used.
How do we know he was speaking on behalf of the church?
Your Honor, that would be a question that could be asked in discovery should this case proceed.
Yeah,
A simple
and
question.
isn't that precisely the problem, though? We're supposed to ask who can speak on behalf of the church? So what if the church says, no, he wasn't speaking on behalf of us? And then we're going to decide as a religious matter that he was speaking on behalf of the church?
First of all, Your Honor, the church has never questioned that issue. In fact,
Yeah.
in the
But
record
in
below,
that hypothetical, what would happen in that case?
hypothetically, if he was not speaking upon the church and if the church chose to distance itself, which it had the opportunity to do, I mean, that statement was made, as we know, in 2012. This case was filed in 2022. There was ample opportunity for the church
So
to say
what
no.
would happen in that case, though? Then we would have to say the church is wrong, that Keith McMullen actually was speaking on behalf of the church.
The church would, in your hypothetical, if the church denied that Mr. McMullen was speaking on behalf of the church and said, no, none of these 5 individuals were speaking on behalf, and really it was something completely different, even though one of the individuals, President Hinckley, was, according to the church, was speaking on behalf of...
But the bottom line is we can say, no, the church is wrong. Keith McMullen was speaking on behalf of the church.
Based on the record, yes, and in your hypothetical, we'd have to address it on the facts at bar. But the issue...
But how is that not deeply entwined with religious matters then?
Because if that was deeply entwined in religious matters, a simple issue of is somebody speaking on behalf of an organization, where would we even draw the line as to what's religious and what's not? So long as linguistics and vernacular are religious, I mean, this gets back to the issue of let it be and tithing, and it wouldn't be equitable or consistent with the intent of the First and 14th Amendments and the doctrine stemming therefore to say that simply to use this circuit's terminology, simply because you invoke religious terminology, you're now cloaking civil torts in immunity. That's not the purpose. When there are issues here, and this again gets back to the questions, these are accounting issues. The church...
Counsel, with respect, if I understand the record correctly, President Hinckley never said these are accounting issues. Mr. Huntsman was a member of the church for many years, continued to pay well after President Hinckley said what he agrees he said. He says that he understood President Hinckley to say that tithing was treated in 2 parts. There's the principle it's given, and then the reserve. The church later showed that it was just the reserve that was being used. You got 4 statements after the original statement that he didn't break it down that way. But Mr. Huntsman knows, and the record shows, that unless you want to get into LDS doctrine, which you can't do, President Hinckley is the only person who is authorized to speak authoritatively on behalf of the church. So you say that's not true, but then you get into church doctrine to say otherwise, do you not?
Respectfully, no, you don't, Your Honor.
How's that?
First of all, Mr. President, Hinckley was not the only person to speak on behalf of the church. And
on what do you rely for that?
I would cite to Presiding Bishop H. David Burton's statement.
The presiding bishop of the church is an inferior officer of the church. There's only one prophet and president of the church. Mr. Huntsman's record indicates that. He speaks for the church, nobody else. So how do we, now you would say that's not true, but then we would be required to get into the LDS doctrine and for you to show that he wasn't the only person, right?
No, Your Honor, we'd have to apply common law issues, again, under
Unless
neutral.
unless the Constitution says otherwise, right?
No, Your Honor, we would have to apply neutral principles of common agency law as to if somebody is holding themselves out as a representative of an organization, as a bishop and a president, and a statement made by the church to the church's publication to say after the fact, to Monday Morning Quarterback, and state, no, that wasn't a statement on behalf of the church because the LDS's official spokesperson is not President Hinckley, would open up the door for every religious organization, including in Rashid. It wasn't just Pastor Rashid who made the statement. It was Pastor Rashid's colleague who was not the pastor, was just a minister, the same way that Presiding Bishop Burton is not the president, but everybody would be exculpated if they could say, well, other than the ultimate be-all and end-all top of the pyramid person, everybody else isn't speaking for the church. That would be inconsistent.
Well, would it? Because in this case, if you're looking at LDS doctrine, that the answer to that question is absolutely yes, he is the only person. And it's not agency law, it's religious law. And I don't understand how you can determine by applying common agency law to what LDS doctrine is. And if you're trying to get into LDS doctrine, it seems to me that the First Amendment bars us to consider it. Isn't that right?
And respectfully, no, Your Honor. If
Why?
we look at the record here, the representations that were made, starting with President Hinckley, where it may have been qualified, but continuing.
It was qualified, and your counsel, I mean, your client apparently recognized that. He understood it. He heard it. He saw that President Hinckley was saying, you got tithing and you got basically reserve earnings, and from the earnings of entities owned by the church. The church has shown by the record, as I understand it, that that's all that was being used to do the city development, City Creek.
Well, that is the church's position. Mr. Huntsman's declaration.
Isn't that what the record shows?
No, Mr. Huntsman's declaration, if we look at the record at page 44 to 45, he doesn't differentiate. He just took President Hinckley at his word. And if we look at the qualification of Mr. Hinckley, meaning not his qualifications to be the president, but the qualifications of his statement that.
Okay, if you took him at his word, then you take the first statement, then he would understand what President Hinckley was talking about, right?
The issue here, Your Honor, is we can take that. We don't have to, if the court is so inclined, not to look at the subsequent four statements. If to take Your Honor's position, as I understand it, that President Hinckley is the be-all and end-all. And we just look at his statement. And we look at how his statement has been explained in the record, as he was referring purely to principle. That does not change the ultimate disposition of this case.
Who said that he was just referring to principle in the first talk?
I'm sorry, Your Honor?
Who says that President Hinckley in his first remarks was just referring to principle?
The church, Your Honor.
The church says that?
The church has differentiated in their papers between the principal donations made by members and the interest generated by the investment
and that's
of
exactly, and that's what I'm exactly what I'm saying. President Hinckley made that clear.
Counsel, I want to ask a question on a different matter. I guess, what's your best case to support that there was a misrepresentation here, or that there was a factual dispute regarding the misrepresentation, especially given that the church told its members that it would fund them all with earnings on invested reserves? It appears that that's what occurred. So I wanted to give you a chance to address that.
And respectfully, Your Honor, we would disagree that the record shows that's what occurred. What we have in the record is the church's testimony. And again, let's take, so we're not delving into meanings, let's take President Hinckley's after the fact explanation in the record as to what he meant, principle. Let's look aside for a moment for the issue of interest. Let's just look at the principle. We have sworn testimony from David Nielsen stating, and this is in the record at pages 80 through 82, stating that principal tithing funds were used to fund City Creek Mall, and that beyond that, principal tithing funds were also commingled with the earnings on the principal. However, he's clear that even without looking at the commingling, principal tithing funds, and that goes, and this goes to Judge Smith's question as well. It has to do, and this is my second point, with inferences. We are on summary judgment. And despite all the First Amendment and 14th Amendment and constitutional issues, if we really look at what we're talking about here in the posture of this case, which is what's on appeal, we are at summary judgment. And on summary judgment, all of Mr. Huntsman's evidence must be taken as true, and all reasonable inferences must be drawn in favor.
Counsel, I'm sorry to interrupt you. Before you run out of time altogether, I want to give you a chance to address the diversity jurisdiction, because my concern is, I'm not sure on this record, without further factual findings by this court, which wouldn't be appropriate, that there's enough to determine his domicile. As you know, the burden is on Mr. Huntsman to demonstrate diversity jurisdiction. He moved to California shortly before the lawsuit was filed, but his company had a filing with the state of California that has the Utah address. So to figure out domicile involves an evaluation of a lot of facts, and a lot of them doesn't appear to be on the record.
I appreciate that, Your Honor. And if I may respectfully put a pin in my answer, I will come back in about 45 seconds to the inferences.
Yeah, I have a follow-up for you as well. Go ahead.
Fantastic, Your Honor. To Judge Wynn's question, if we look, as you've recognized in the record, at 213 and 214, what we know, which in and of itself is a far cry from the facts of Lou v. Moss, we know that Mr. Huntsman moved his family to California in October of 2020. We know this case was filed in March of 2021. We know Mr. Huntsman moved to California to be closer to his business, which is located, notwithstanding where it may be registered, but it's located, its offices in California. We know Mr. Huntsman came here he wanted to be closer to the ocean, he said too. And we know that at the time that the case was filed, there's no indication, unlike in Lou v. Moss, that Mr. Huntsman had any intention to be anywhere else. And if we look at the circuit's decision in Mondragon v. Capital One Auto Finance, this circuit contemplated, without applying it there because the facts were different, that a court may treat a party's residence as a presumption of domicile. In fact, other circuits
Actually,
have done
under
that.
Lou v. Moss, the presumption is in favor of his established domicile, which is Utah. So I'm trying to figure out whether he overcame that presumption with what's currently in the record. He obviously has the ability to have homes in a lot of different places. And I know his business, Blue Fox Entertainment, had a California address, but the filing actually listed his personal address as a Utah address. So there's just a lot of, given the timing of it, my concern is that the presumption should have been triggered, and the district court, we would have benefited from findings by the district court, but neither party really raised this issue below, and the district court didn't sua sponte examine this issue.
And we agree, Your Honor. While, of course, the court could sua sponte address it, it was never challenged by the court. Therefore, there was never any response by Mr. Huntsman. And until this panel had raised the issue, it's never been in dispute. That said, we would welcome, if there's concerns by this panel that necessitate a remand to the district court on the limited issue of domicile, we'd welcome the opportunity to clarify the record, put in the evidence either through declarations or documents or depositions on that issue. That would not be a problem. And so it is a resolvable issue either through the presumption based on what's in the record already, which again is not like Lou v. Moss, where the person was living in hotels in the challenged domicile at the time. This is Mr. Huntsman was living in California, had his family here, moved here. I see a question.
Yeah, sorry. Thank you, counsel. Do you have a position on whether or not the church autonomy doctrine is jurisdictional or not? I mean, it's an important question because whether or not we could skip right to the fraud analysis, or do we have to address this question of the First Amendment?
Your Honor, it is jurisdictional insofar as conceptually a Article III court cannot, I'm not aware, maybe there is a case that states it in terms of specific jurisdiction, but conceptually, yes.
Watson does say jurisdiction, but that was like over 100 years ago, so I'm just wondering.
Understood. And recently, conceptually, perhaps yes, insofar as if a church has to delve into issues of doctrine, the church cannot do so. But to address the issue here, it's a moot point because our position is, again, not our position, but the position of every judge that's looked at it so far,
apply.
is that this is secular. And again, it just gets back to,
Can I ask you just on this point? One question one would have looking at the lawsuit is whether, if this lawsuit is allowed, will it invite a flood of lawsuits by people who become disillusioned with their religion? Because many people are religious or belong to a religious organization, then decide that it's not for them. And in this case, the speech that we're speaking of is really more of a sermon. And are we going to, if this case goes forward, are we going to have situations in which lots of people are suing their church or their synagogue or something else, asking us to resolve claims of religious nature?
Your Honor, I see my time, once we take into account rebuttal, has run, and I would like to have time to respond to Mr. Clement. I'd be happy to answer your question, but I just wanted to.
You should go ahead and answer Judge Preston's question.
So the answer to the question is no. The precedent set here is very, very limited. If we find, and again, this goes to the slippery slope, and in fact, if we just say, had Judge Fletcher's prior opinion not been vacated, it would have had no impact whatsoever on how the church or any other religious organization practices its religion. The only precedent set by that opinion, now vacated, or that by this court's opinion, if it's reinstated, is that a church in this circuit cannot lie about how it intends to spend the donations of its congregants. And so if that's the precedent that's set, we would submit that's a proper precedent. It's not inconsistent with doctrine. It doesn't require an analysis of doctrine. It is secular. The same way it was secular in Rashid, the same way it was secular in every case thus far that's looked at the issue of fraud, not employment decisions. Your Honors, I'd like to reserve
your
the right,
time.
just very quickly. In conclusion, tithing is a religious practice. Fraud is not. To hold otherwise would open up the floodgates to a litany of serious civil torts no longer being punishable. Thank you, Your Honors. I respectfully reserve my time.
So now this will be the attorney for the church, everybody.
Good afternoon, Your Honors. May it please the court, Paul Clement for the appellees. There are at least two fundamental problems with the fraud claim by a former church member against his church here. First, there's no misrepresentation. The leader of the church explained that financing for a particular project would come from two buckets of church money and not from a third. And that is exactly what happens, as the record reflects. Second, and even more fundamentally, this kind of tithing refund claim is barred by the church autonomy doctrine of the First Amendment. This case ultimately boils down to the question of what a church leader meant and what a church member understood when the former talked about tithing funds in contradistinction to earnings on invested reserve funds.
Counsel, can I ask you something? Because you had briefed and argued this case as first and foremost, no triable question of fact, summary judgment should have been granted, and secondarily, the First Amendment. But I would have thought that given the church autonomy doctrine, that the arguments would go the other way in terms of the order. So I'm curious to see what your response is as to, why the defenses set up the arguments that way. And secondarily, assuming that the church autonomy doctrine doesn't stand in the way of reaching the summary judgment issue, there is still the declaration of Mr. Nielsen indicating that funds were commingled.
So there are two questions here. Let me try to answer them in turn. I think it's a challenge for a church when they feel they are falsely accused of fraud in the context of the church leader speaking to the flock. It's a bit of a conundrum. Do you try to essentially clear the church's name by saying there's absolutely no misrepresentation here? Even if this were a completely secular case, there'd be no there. Or do you say instead, this is the religious autonomy doctrine, the church autonomy doctrine? I think in fairness, the church was so convinced that there is just no there here, that it essentially wanted to clear its name and say, look, the easiest way to decide this case is to decide that there's absolutely no misrepresentation here at all.
That's where I figured the answer was. But now then on summary judgment, if you want us to go there first, there is the declaration saying that the funds were commingled. So why doesn't that create a triable question of fact for the jury?
It absolutely doesn't, Your Honor, because the fact that the funds may have been commingled for some purposes makes absolutely no difference under the secular law or under the church understanding of what President and Prophet Hinckley said. I mean, it may well be that the people that worked at Ensign Peak looked at all the funds under their management, which at some broad level, like all church funds, probably came from the faithful. The fact that they looked at all of those funds as in some sense sacred, as some sense the widow's mite, as
Well,
some...
maybe I'm misunderstanding something, because I thought the President Hinckley's statement was that no tithing funds will be used, but that earnings from reserves would be. But in a commingling situation, then there may be an issue as to how that's teased apart.
But here's the thing, Your Honor. I mean, they may have been commingled for purposes of making an investment, but there was very careful record keeping. They were not commingled for accounting purposes. And what the record here reflects in an irrefutable way is that the funds for this project that started out with $1.2 billion on January 1st, 2004, and then were segregated from all other funds, that $1.2 million came from earnings on investment returns exclusively. And that is the unrebutted testimony, unrefuted testimony of Mr. Writing, and that's in his declaration in paragraph 14, and that's in excerpts of the record 538. So everything that was used for...
I just want to follow up on this, because it seems that Mr. Huntsman is arguing that the church was fraudulently misleading because it did not speak with sufficient clarity about how it would use the tithes, these tithes. And so I'm just trying to figure out, why is he wrong, given that the 1991 and 1995 statements that are in the record point to several years removed and are not referenced within the 2003 statement.
So, I mean, two things, Your Honor. First, to the extent we're saying, as Judge Fletcher did for the now vacated opinion, that the problem here is that the head of the church didn't speak with sufficient precision when addressing the faithful about tithing, I think that's why this is a First Amendment problem. But I don't actually think, in the President and Prophet's defense, I actually think in 2003, even if you look at that document in isolation, he spoke with sufficient precision, because he is, in a way that some of the Ensign Peak employees at a later time are not. He's talking about three different buckets of money, and he is distinguishing among and between those three buckets. And he says, okay, the church has some earnings from commercial ventures, and that corresponds to the fact that there was $150 million from an entity called PRI, that's the church's sort of real estate arm, that's used as some of the seed money for this. So he talks about that bucket. Then he talks about another bucket that's distinct, which is, and I want to quote him directly, the earnings on invested reserve funds. And then he talks about a third bucket, which is tithing. Now, in a context where you're talking about those three buckets, I think it is clear, even without the 91 statement, even without the 95 statement, those earnings on invested reserve funds are different from tithing, which is, in the context of that distinction, more of the ongoing annual tithing of the faithful. And the only sort of contradiction here is the testimony in the Nielsen Declaration, which is all of 3 pages long, so I invite you to read it. It is not particularly damning. But he says, well, when they were working at Ensign Peak, they talked about all their funds, which included current year tithing funds and earnings on invested reserve funds. They talked about all of them as tithing.
Counsel,
Now,
I would like to essentially piggyback on Judge Bumate's question about the First Amendment abstention doctrine. And if I understand your argument to have been that if we were to agree with the district court in the sense in the now vacated 3-judge opinions reasoning on the merits of the fraud claim, that there was no need to abstain, but that it's only when you don't agree that you start to get into church doctrine, and then there is a need to abstain. As a matter of abstention doctrine, as versus the pragmatic concern you mentioned before, is that still your position that that is doctrinally correct?
So I don't think I'm not aware that we took a position on that before. Let me tell you what my position is.
What is your position now,
And
then?
this is just my effort to be helpful to the court. I mean, it might be tempting for me to say, yeah, it's jurisdictional, and we really would love you to decide the First Amendment question right now, but I don't think that's right. And I think there was a lot of confusion in the courts before Hosanna Tabor, but in footnote 4 of Hosanna Tabor, the Supreme Court clearly labels the ministerial exception as an affirmative defense. And then a few years later, in Our Lady of Guadalupe, they say that that the ministerial exception is just a subspecies of the church autonomy doctrine. So I think if you put the Supreme Court's 2 latest pronouncements on this question together, you are left with the inescapable conclusion that this is not jurisdictional, it is an affirmative defense.
Counselor,
and that is, I should just add parenthetically, that is the virtue, of course, being coherent and true. There's nothing about Article 3 about the church abstention doctrine.
Can I just change the focus a little bit? The church primarily defends itself on secular grounds on the basis that it was very clear what President Hinckley said at the beginning. When you look at what he said, when you look at what the accounting record showed, and the fact that the former employee of Ensign Peak wasn't there when this allegedly occurred, that it doesn't really matter what the employees said, they weren't the prophet. What I don't understand is why the definition of tithing funds, by definition, doesn't run into a First Amendment problem. If the First Amendment basically eclipses this, we don't even get into a summary judgment issue. We never get to it at all. Why did the church take the position that this was just secular?
So I don't think the church ever took the position this was secular.
Not just my reading.
Right, no, I think they took the position that there was no misrepresentation here at all. And as I alluded to, I mean, I think that's actually an understandable temptation for any church when it's accused of fraud or misconduct, because obviously it's important to the church to be, above board, holier than thou, whatever phrase you want. And so there's just this temptation to say we did nothing wrong. Now, I think
I get that. I'm just saying, since we're dealing with your colleague over there, he's saying, hey, look, this is just a sort. It's a tort. We think it's all secular. You seem to say it's secular. It all comes down to who said what, when, and where. It's a material issue of fact. But if you have a focus on what the tithing means, then you run into the religious protection issue, which you never get to the other one. Help me with that, please.
I'm happy to help you. I guess what I would say is, I think ultimately the temptation that this church or any church has to defend itself as if it were a secular entity is maybe, upon reflection, the best reason to apply the religious autonomy doctrine at the threshold and just say, we're not going to put churches in this position, because we're going to make it crystal clear that when a member or former member of the church sues for a tithing refund, absent unusual circumstances, and I think there probably are exceptions for embezzlement or cases that would be different, where it's not general tithing, but it's a specific representation for a particular purpose, and then the funds are diverted.
There's nothing in this case, if I understand correctly. Nobody's claimed that the church had a Ponzi scheme. Nobody claimed that some person enriched themselves or provided jewels and so on for somebody. This is strictly an issue of the president of the church, who by LDS people if he is the person, the authorized person, says what it meant. It didn't change. Mr. Huntsman apparently read that, understood that, if I gather. He's taken the later 4 statements. He says, well, that's confusing. Well, it's not him to decide, right? Otherwise, you have lay people deciding what the doctrine of the church is. And that, to me, gets back to the church autonomy doctrine, which maybe should be governing this case.
I don't disagree. I think the church autonomy doctrine squarely covers this case. In my opening, I was going to give you 2 sentences on where there was no misrepresentation, and then I was planning to talk to you about the church autonomy doctrine for the balance of the time.
So if we were to go with the church autonomy doctrine and rationale, it sounds like you were starting to say that there would be still some cases that could be brought, and I'd like to hear more about that, like a hypothetical where there's been some tragedy, there's a fire in the next town, and now you've got orphans because their parents were killed in the fire. And the church says, we're collecting for these kids, everything in this basket will go to the kids. And then they spend the money on new clothes for the minister. Is that a case that could still be brought under your
Under my view, that is a case that can still be brought, and essentially doubly so. Because the way I would sort of think about this area of the law is you start with the presumption that the religious autonomy doctrine applies, but there are exceptions. The two exceptions that I think have been recognized by the courts over the years is one, call it embezzlement, just call it, whatever it is ends up in the church leader's pocket. And then the second situation, which I think is different, and I think you could allow the claims to proceed without running afoul of the doctrine, is where it's not general tithing, it is a specific solicitation for a specific purpose, and then the funds are diverted. And I think that latter case is different largely because a whole second problem, and I believe Judge Bress alluded to this in one of his questions, but a whole separate problem under the church autonomy doctrine with this claim is with the reliance element. Because when it's tithing, from the church's perspective and from the perspective of a faithful adherent, that is a commandment, that is a scriptural commandment to give 10% of your earnings or your increase or your income that is really wholly independent of what the church does with it. And that's not the case, obviously, when it's a solicitation for everything in this basket's going to go to hurricane relief in a particular place.
Are there limits to that, though? So say it's Catholic Church that has always said we're against abortion, and they collect tithes, and then they say we would, of course, never support abortion, and then they collect a bunch of money and they pay for abortions with it. Could you sue?
I don't think you could. I think that's a hard case. It's a hard hypothetical. I understand it. But I think in that kind of general tithing thing, you might be able to leave the church over it, but I don't think you can get a refund under those circumstances.
And why not? That's because there's some religious ambiguity about what abortion means, or what would be the reason?
Well, I mean, I think of it this way. I mean, one reason might be that the church might change its doctrine on the issue, and you'd still have these refund claims. And I think if you go down that route, all of a sudden, I mean, in the secular context, the SEC's developed a safe harbor for forward-looking statements. And I just hate for this court to have to impose that on religious leaders when they talk to their flock. And that's exactly what this is. This statement 2003 is a forward-looking statement. It says no tithing funds will be used for this purpose. Now, it turns out that under President and Prophet Hinckley's definition, that's exactly what happened. But if that changed for some reason, would that be a basis for somebody to get a refund? Would it be a basis for the courts to be, even in the hard hypothetical you gave me, you'd still have this problem of the Catholic parishioner coming in and saying, well, I would have never given my money if I knew that was going to happen. And then the church would be saying, well, that's not right. You actually, as an adherent Catholic, you have an obligation, a commandment to give tithing as well. And so there's a jury question over whether or not there was actual or reasonable reliance in this case. I suppose if you were really going to adjudicate this, you could have one side bring in an expert on Catholic church doctrine. You could have another side bring in an expert on actual practice of Catholics when it came to the collection basket, and then you throw it all to the jury. I think that's a pretty good explanation for why the church autonomy doctrine would apply, even in that hard hypo.
Could I ask you a question about co-mingling? And I don't know if this is the church's position, but if the funds from tithing went into Ensign's bank account, and then the earnings were accrued in that, and so it's commingled, but if the church establishes that the earnings themselves far exceeded the investment that would go into the City Creek project, is that the church's position as to why there's no misstatement? Because even if there's a commingling of the funds, the earnings themselves are more than sufficient to cover the cost of the investments, and therefore that's why President Hinckley did not misstate anything. Is that the church's position?
Well, if those were the facts, I think that would be the church's position. But the facts are even better for the church because there was not commingling for accounting purposes, and indeed. After January 1st, 2004, the record clearly shows that that money was set aside for this project. $1.2 billion was set aside specifically for this project, and then that was always treated separately. That there's an account that shows every withdrawal from that account. It shows that was basically drew down on until March of 2012, where at the end there was still $151 million in there. So, and then we have testimony from writing. That's paragraph 15 that I've already alluded to. that says that $1.2 billion came exclusively from earnings on reserve funds. So under this record, I don't have to, and this is something else that you'd get into if you got to the reliance element. I mean, at a certain point, money is fungible. And so if the church hadn't been as careful in its accounting, I think I would still be up here saying, like, what are we talking about? In year 2003 alone, the church had earnings on reserve funds that are well in advance on anything they spent on this project. And so there's just no issue that, like, they had to go into
Is it your view?
tithing.
Is it your view that the Nielsen Declaration does not create a genuine issue? Because even if Ensign used shorthand to say it's all tithing, that doesn't make it so. It's what the church is saying that is what's important for purposes of this distinction between earnings versus the principal.
Absolutely. And Judge Smith was alluding to that earlier, but there's only one person that can speak authoritatively for the church on the meaning of tithing, and that is the president and the prophet Hinckley. And so if other people in the church are using loose language, that is just irrelevant as a legal matter. I just have to add, though, like, even in a secular setting, I could imagine the same thing, because President Hinckley is being very specific about 3 buckets. And in that context, he describes one of the 3 buckets as tithing. If somebody else in another context is not differentiating between 3 buckets and is just talking about one bucket and describes it as tithing, I mean, look, try to find like a simple secular example, but there's blueberries and then there are blueberries. Not all berries that are blue are blueberries. And so if somebody's talking about that in one context and they very specifically distinguish between blueberries and black raspberries and blue raspberries, well, then you'd understand it one way. And if somebody else is saying, oh, they're all blueberries, like, you wouldn't think that was a fraud claim. And at some level, that's all that we have here.
Can you explain why we're carving out embezzlement from the church autonomy doctrine? It seems like it'd be the same interest. Are you saying that there's a text and history of that, or something of that nature?
So when the courts have come up with something that is that egregiously self-dealing, and that's really this court's decision in Rashid.
Mm-hmm.
I think what the courts have done had they've maybe call it a cheat, but what they've done is they've said there's a sincerity problem.
Right.
And that's the way they've
Different than carving out embezzlement, though.
It comes to the same thing at the end of the day, and not every court has gone the sincerity route. But that's the way I think the courts have mostly approached that. I also think that the reason maybe they're sort of joined at the hip is at a certain point, the reliance question, I think, becomes more straightforward when very few people are actually going to give money to the church if they just think it's going to be embezzled. So
You said you were going to start, I'm sorry, you said you were going to start out by saying there was no misrepresentation here, and then go into the church autonomy doctrine. I mean, are you suggesting that is the way we can resolve this, is just say there's no misrepresentation and end it there?
that is a way you could resolve this case, and you could say not one word about the religious autonomy doctrine, and I would be happy to win this case for my client on that ground alone.
Can you talk about sorry, go ahead, Judge Freeland.
Could I just go back to, so the hypo, I think you said there were 2 things. So there's the fire, and you've got kids who have no parents, and they say this basket of money is going to go to those kids. Let's get rid of the clothes for the priest and say instead they spend it just on a hurricane somewhere else. Is that a claim?
I think that's a claim. But because I think that's a distinguishable situation where it's a solicitation for a particular reason. And if those funds are diverted to something else, I think that's a different, I think that's a claim that you could bring. And I don't think.
Not just embezzlement, it's broader. Yeah.
Right. I took the question to be, in some respects, it's harder to explain the embezzlement exception than it is the specific solicitation diversion. At least I find it harder to explain the embezzlement exemption, but it's there in the cases. And I do think, as I say, whether you call it a little bit of a cheat or you just understand it as a unique situation where there's just no real practical difficulty in proving reliance.
And in this case, there is no allegation, I gather, of a specific request to use tithing for this specific fund. That's the church's position, right?
That is the church's position. And one of the things that makes this case so extraordinary, of course, is we're so far away from these other examples because the church was completely forthright that it was going to use church money for this particular purpose. And then the president added, I suppose, gratuitously and maybe unfortunately in hindsight. All right, but I'm going to be clear, there's 3 buckets of church money that we could use, and we're only going to use 2 buckets. We're not going to use the 3rd bucket for this
So
purpose.
in this case, where if the church takes the position, he's the president of the church, the prophet, and church members are asked to contribute tithing based on worthiness. They only get to go to the temple if they do that. They're supposed to get certain blessings. There's never any discussion about how it's going to be used in church doctrine. So if you have that situation, you get back to what was actually said by President Hinckley, you don't have the example that you give where they said, we'd like you to contribute some money for this, and we're going to use it for this, which is contrary to the normal doctrine. And that answers, I think, my colleague's question. If there's a specific request to use money for X and they don't use it for X, that might be different. But that's not the way tithing is solicited, is it?
Well, yes, and tithing really isn't solicited in the same way as limited purpose funds are, which is why in describing sort of the metes and bounds of the doctrine, I would describe it as tithing refund claims are presumptively covered by the church autonomy doctrine, subject to these 2 exceptions. And I think that would provide a clear rule, and it would have the incidental benefit of avoiding churches from being in the dilemma that my clients were in, which is they don't want to just rely on an immunity. They want to, they've been accused of wrongdoing and they want to defend themselves. But if you make it crystal clear that there's a broad doctrine with 2 exceptions, then I think that it's much easier for churches in future cases to say, we're going to get rid of these cases at the threshold. And it also prevents the, opening the floodgates. And Judge Bress asked a question about this as if it were a hypothetical. But since this panel decision, there have been multiple class actions brought against the church, and I don't think it is a problem that is limited to my client. Other churches are here as amici because they're worried about this same thing, and I think the reason they're worried about it is every church has adherents that then lose their faith. Now, if those former adherents came into court and said, well, I want all my money back because, for years I was told I needed to give this money to save my immortal soul. And now I've decided all that immortal soul stuff is bunk. There's no afterlife. This is it. I want that money back. I'm going to Vegas, whatever. Like if they tried to bring that claim, they would be laughed out of court. Of course, you can't bring that kind of fraud claim where you bring in experts and say, all this afterlife stuff is bunk. But there's a profound temptation in that circumstance to, go back and fly spec all of the sermons and say, oh, well, I was told something about abortion, or I was told something about this City Creek project. And well, in retrospect, I wouldn't have given my money. So I want to do a secular fraud claim instead of the obviously improper religious fraud claim. I think there are good reasons to stop that at the threshold.
Sorry to interrupt you because I know your time's running short. Can you spend a minute addressing the jurisdictional issue? Because it seems apparent to me that the Church's Council were aware, and just the way that they questioned Mr. Huntsman during his deposition had flagged this issue for themselves, but then it just kind of like petered out. Is there a reason for that? Is there a downside to remanding for additional factual findings by the district court before we take up the merits of the case?
So, if this court can, instantly reconvene the en banc panel after it sends it back to clarify what I think is true and have no reason to doubt, I don't really, I barely have standing to object to that. I think if the consequences of that were that we had to go back to square one or something, I think it was not the best use of this court's resources. I guess, to answer the question, we asked some questions in the deposition. The answers were such that combined with the averments in the complaint, we didn't think we had a basis to question his domicile at the point that he filed the complaint. He alleges he's a California resident, which I know there's kind of these competing presumptions, the presumption in favor of the old sort of domicile, but there's also a presumption in favor of residents being the domicile. As my friend on the other side says, we're miles away from a situation where the only new domicile is a hotel room. And then you add to that the fact that there was a specific allegation that there's complete diversity in the citizenships of the parties, which was a separate allegation in the complaint. I think we took all of that, everything we heard in the deposition. We did not think we had a good faith basis to question what is, this is, it's a weird situation in a sense because the question is ultimately, I mean, although testimony intent is not dispositive, the legal question is ultimately the intent of the person at the point at which they filed the complaint, and we don't think we have any basis to question that. And I would say, maybe this is another reason why the church autonomy doctrine should apply, but puts a church in a weird position where it has to call its former member a liar, at the jurisdictional threshold, which is essentially what we would have had to do if we doubted his averments in his testimony.
Counsel, can I ask a question? What are we to do with Watson, which did call it jurisdictional? I know that wasn't a constitutional case, but it does seem relevant to how we look at this now.
So, the Supreme Court multiple times since Watson has said that jurisdiction is a term of many meanings,
Right.
too many meanings.
Right.
And so I think when you put that more recent observation of the court together with what it said in Hosanna Tabor and what they then subsequently said in Our Lady, I think as a lower court, you do not have to tie yourself to the mast of what the court said in Watson. I think you are free looking at the Supreme Court's.
Although that footnote could also be considered dicta, don't you think?
What's that?
That footnote in Hosanna Tabor could be also considered footnote.
I've read theories that is dictum.
Yeah.
I would take my chances with saying that's a holding, and think that's a safer course than saying we're bound by Watson as the holding.
So, counsel, in this case, if we were to resolve it over what I'll call the first ground, which is the non-constitutional ground, that would be solely a question really of California law, correct? You agree with that?
I would agree with that.
So there are a lot of other states in the country, and I'm curious, would there be other states that define fraud differently that would then, in a sense, bring this case right back to us if it was brought in Nevada or brought in Idaho or Utah? Or do you think that, or do you not see a difference?
I don't see a material difference. I mean, there's probably some state out there that has a funky concept of fraud by omission, but I think, you really don't get a fraud claim anywhere without a misrepresentation.
Does the church have any sense of how many copycat cases were filed against it as a result of the original panel's decision?
Well, there's been at least half a dozen, but most of those have been styled as putative class actions. Right. And there's sufficient litigation against them that an MDL has been convened.
Got it.
So that's why I say the floodgates concern here is not hypothetical. It is real, and it's all since the panel's decision in this case.
Are they all California cases, or do they vary?
They're brought in multiple jurisdictions. So let me just close with one point of context here. I mean, among the problems with this claim is not just that you can't decide it without deciding the definition of tithing, but you can't really decide it without saying that the supreme leader, the supreme religious prophet of a religion with 17 million adherents, basically committed a massive fraud on his followers when he was speaking ex cathedra. Now, I don't think that proposition alone decides the case for the reasons I alluded to in the exceptions, but it sure contextualizes the case and sure makes clear that the autonomy doctrine should apply. Thank you.
Thank you very much.
So now Huntsman's attorney will get a chance to use that additional 5 minutes he reserved.
Your Honors, I'd like to make 3 brief points on rebuttal. First of all, with respect to Judge Wynn and Judge Smith's question on characterizing the First Amendment as really the fallback argument here, that's precisely right. What's strange about the posture here is that the church put its financials on the table. This is not a situation where the church said, we're called out for our financials. We're not giving them to you because it's First Amendment protected. The church went ahead and put its financials on the table and characterized them a certain way. And it was only when Mr. Huntsman, again, who inferences must be drawn in favor of, put his own contrary declaration on the table and said, no, tithing principal funds were in fact used, that all of a sudden the church said, oh, this is a constitutional First Amendment issue up front and center. It was after the prior vacated decision recognized the triable issue. So it's patently unfair, we'd submit, for the church to put their financials, and then when those financials are questioned, which again is a secular issue, it's anybody with an accounting degree, any high school student, even an elementary student who takes economics or anything, simple math. Let's count up what's in this pile, let's count up what's in this pile, and let's see if that's consistent with what we submit as a secular statement by President Hinckley about which pile was used. That's a secular issue that creates a triable issue under the summary judgment
On that one,
rules.
are you saying co-mingling is combining the piles? Because the Nielsen talks about co-mingling as I read it, and I'm not sure you have evidence that there really were two piles and they took from both. You just have one pile together, right?
No, Your Honor. If we look at the actual documents, and again, this is what's strange about the case. The church keeps saying the documents show, the documents show. The documents don't even mention the word tithing or tithe once. The documents are questionable, and if the case moves forward, there can be discovery and follow-up questions concerning those documents. We thought it was sufficient for the purpose of summary judgment that a sworn testimony of somebody who has percipient knowledge, having worked for the church's financial arm, would at least create a triable issue. But there are numerous follow-up questions, not about the church's business decisions or about how they're conducting things, but simply, these are financials. Why don't they say tithing? Why don't they differentiate between principal and interest? As the church said, these are accounting issues that you wouldn't need a doctrine expert, you would need a CPA to resolve. And to say that this is a First Amendment issue, or even that there's no triable issue of fact at this juncture, when inferences need to be drawn in favor of Mr. Nielsen and not the church and Mr. Writing, would be to prematurely decide this case for the wrong reasons. Finally, with respect to Judge Friedland's hypothetical, your hypothetical about you're raising money for orphans and instead you're spending it for something else. And my colleague says, no, that case wouldn't be precluded by a decision in the church's favor here. To the contrary, it would. Because if it's okay here for the church to say where the money's not going to go and to do it dishonestly, then it's fine for somebody to say where the money will go and to do it dishonestly. It's two sides of the same coin.
Doesn't it turn on the baseline obligation? I mean, here the obligation is to pay money as a religious commandment. In these other hypotheticals, it's sort of like a conditional donation. I'm giving this money for this particular purpose. Don't you think there's a distinction between the two?
No, Your Honor, because the church in this instance set its own its own secular condition on the money. The church said on 5 separate occasions, the money will not be used, including not 1 penny of this pile will be used to fund City Creek, and Mr. Huntsman relied on that. And if it turns out from the documents that even 1 penny was used, it was a misrepresentation, not under the First Amendment, not under the 14th Amendment, not under the church autonomy doctrine, under California neutral
Counsel,
principles
on
of
the
law.
question of the accounting, my understanding for your, to create a disputed material fact, you're relying completely on the Nielsen Declaration. And regarding the seed money for EPA, as far as I could tell, the entirety of his declaration was that according to what senior leadership of EPA informed me in 1997, EPA was formed and was seeded with tithing money. Is there anything else in the record specifically that you're relying on to create a genuine disputed material fact regarding the source of the seeding money?
Your Honor, frankly, it wouldn't be possible for there to be something else in the record at this juncture because there's been no ability. If we remember the posture, this was remarkably ordered to summary judgment a few months into the case at what was supposed to be a conference to discuss a discovery calendar and a trial date. None of that was done. All there was a single deposition of Mr. Huntsman, and there was a declaration from Mr. Nielsen. And if this case moves forward, which it should, there will be an opportunity to flesh that out. But to say that because the church is able to put in, again, documents that we submit don't really stand for much other than how the court chooses to characterize them, but we can't then follow up and ask what they actually stand for, consistent with Mr. Nielsen's declaration, again, on personal knowledge, as you just read, would be, again, to cut the legs of this case off prematurely.
Can I ask, why doesn't sincerity fix the problem of Judge Friedland's hypothetical?
It does, Your Honor. And if we look again at the sincerity doctrine here, which notably the first time it's been raised is here at oral argument, the church hasn't had a response to that point in any of its briefs. And that's because the point swings in Mr. Huntsman's favor. The issue of sincerity, again, as was held in Puri and in Rashid, is if you say, this is a commandment of God, we're going to do it this way. And you knew at the time that you said it, just like in Puri, it wasn't coming from investments that were making money because God blessed them. The money was coming just from other members, other ministers. Just like here, the money wasn't, at the time these statements were made, the money wasn't coming, at least according to Mr. Nielsen, from earnings on tithing funds. It was coming from principles. So under the sincerity doctrine, President Hinckley knew, we submit at the time that he said it, that what he was representing was not true on behalf of the church. And that falls outside of the sincerity doctrine because it's not a question of his belief. It's a question of the facts that he was aware of, separate and apart from what a doctrine of God may have dictated to him. These were facts. These were secular facts. And Your Honor.
Thank you.
Yes, thank you.
Thank you very much. Thank you, Mr. Janellis, and thank you, Mr. Clement, for the oral argument presentations here today. The case of James Huntsman versus the Corporation of the President of the Church of Christ of Latter-day Saints is now submitted, and we are adjourned. Thank you.
All right, and now the justices are filing out of the court. I see 10 justices there, Kolby. Is that what you see?
11.
11, okay.
11.
All right.
Well, that was exciting, fast and furious. Maven asked me to tell everybody that, especially if they're watching this back after we're live streaming, there were a lot of live comments that I added as the stream was going on, answering people's questions. So please, if you're watching this after, please review the live chat for comments and questions there. John, what did you think from a high level?
I mean, you're the man. So let's start with you, and then I can share some things too. What do you think?
Yeah, so the first thing I'll start with is so in legal terms, or kind of in legal parlance, we'll call that what's known as a hot bench. The idea is that neither attorney really got a lot of uninterrupted time. The convention is that when a judge goes to ask you a question, that you stop talking and wait for the judge to get the question out. And oftentimes in response to your answer, another judge or the same judge may ask a follow-up question or a completely different question. It's one of the things, I guess, as an attorney I've never argued in front of the Ninth Circuit, but having argued in appellate matters before, I guess I just share with people like how difficult that is, how difficult it is to keep all that stuff in your brain while at the same time fielding these questions. Sometimes that can be difficult to understand. Legal terminology is difficult to wrap your head around, even when you've been doing it for a long time. And they can ask you a question about a case that may not have been like a big feature of the briefing, or an issue that may not have been a feature of the briefing. You heard Mr. Huntsman's attorney reference that right there at the end, saying that, well, this is kind of the first time this sincerity doctrine has come up, is that oral argument. And that's the reality of how these cases evolve, is it can be really difficult to do that. I guess one other thing I'd highlight is there were a lot of critical comments to some of the judges' questions when Mr. Huntsman's attorney was giving his opening comments. One thing I guess I'd invite people to remember is that it's difficult to read the tea leaves there, in that judges will often use a question they're asking the other side that may seem initially like it's confrontational to really just vet a position. So I've given up a long time ago on trying to figure out a judge's position based on the questions that they've asked. And also, I just think that the members of our federal judiciary in particular are due the respect that, we determine what they decide based on the actual decision that they render and write. And so that was my first takeaway. I thought both of the attorneys did a very good job representing their clients. I thought Huntsman's attorney, especially his last 5 minutes, was really, really tight. He was helping people understand the theory of the case. I think he had a few softball questions that were asked his way, and a few difficult questions as well, that he absolutely knocked out of the park. So I thought he did fantastic. I also thought that the church's attorney did a good job. And we'll talk, I guess, a little bit more in a minute about the kind of like the substance behind the case. But yeah, what were your thoughts, or what stood out to you as odd, or any questions you had?
So I was just surprised that they weren't letting him give their original speeches that they had prepared. I really wanted to hear Huntsman's attorney just lay out his position, but I'm assuming he would have filed his speech beforehand and they could have read it beforehand. So I guess they didn't want to burn up hearing time having them read something that they could have read beforehand. But I was just bummed at all the interruptions That was my first reaction. Do you think that they would have filed their remarks and that the judges would have already read them?
Yeah, so they don't necessarily file the remarks that they're planning to make that particular day, but the briefing that they referenced a number of times. So those are the written filings that go back and forth. And in this case, they would have been written and filed a long time ago in advance of the original panel decision, if I remember correctly. And so it would have a lot more detail. Typically, those appellate briefs can be anywhere between, 25 and 50 pages, even more than that, depending on the substance of the case. So that's actually really where the majority of the argument happens. Believe it or not, even though oral arguments are really fun to watch and they can be really spicy to watch and really exciting, the majority of legal work happens in the briefing and in the review of the writing. That's really where the majority of the work happens.
The next thing that I felt, it felt like there were a couple justices that were clearly on the side of the church. I wish I knew the justices' names, but there was that particularly elderly justice, and then there were a couple that I'll just be honest, that had markers of being more religious people in nature, potentially, that seemed to be asking the toughest questions of Huntsman's attorney. And it just seemed like some of the judges, I know you just said that you can't really tell, but there was a judge that did look Jewish, and he even made a reference to synagogues. And then there was that other justice that would appear to me to look either LDS or very Christian. They just seem to be more conservative justices, potentially religious, that seem to be coming down really hard on Huntsman's attorney. I know I'm wading into dangerous territory, but what did you think about some of those justices that seem to be clearly coming down hard on Huntsman's attorney?
Yeah, so the one judge in particular, his name is Milan Smith Jr. He is a BYU graduate.
No, so he is Mormon.
Yeah, and I guess I'm going to pull the standard attorney dodge and just say that it really just depends on the written decision that comes out. I would agree with you that a lot of his questions seem to be essentially making the church's case for it, but that doesn't necessarily mean that that's his position, even though he is a BYU grad.
Okay. Yeah. And we appreciate your diplomacy there. It did feel like he burned a lot of the time of Huntsman's attorney, kind of badgering Huntsman's attorney. That was my impression.
My other impression I had while he was doing that, I do agree with you that he used quite a bit of time going back and forth on, to me, what seemed like factual questions. And again, this hearing is about the law, right? If there are factual questions, as Huntsman's attorney kept reminding people, and as we started today's stream, and I reminded people, at this stage, the law requires that Huntsman is entitled to every favorable inference of fact. And so if there are any unresolved questions of fact, those are to be determined in Huntsman's favor. And the thing I noticed when it seemed like Judge Smith was asking a lot of those types of questions is I saw, and maybe it's just because they're focused on other things, but I saw the chief judge who was in the middle there that we referenced her name, and the other judge that was on the top of the panel. They looked irritated, but I'm just guessing that that's what was going on behind their mind.
Shouldn't that judge, who's the BYU grad, again, Judge Smith, shouldn't he have recused himself from this case because of a conflict of interest?
Judges, so one of the things about so we have canons of judicial ethics, and that's been a matter of national news over the course of the past year with regard to behavior at the federal Supreme Court level, Supreme Court of the United States. All I'll say is that for the most part, judges' ethical duties and considerations are self-policed. And so I'm not saying one way or the other whether Judge Smith should or shouldn't have recused himself. It is surprising to me that someone would believe that they could be completely a neutral decision maker in a case like that with that affiliation, but that's a decision for the judge, not my decision. So I'm not commenting on it beyond just saying I personally don't feel like I could, like, for example, for me, if I were a judge someday down the road, I don't feel like I could personally ethically sit on a case involving the LDS Church. In fact, when people have reached out to me about cases involving the LDS Church, even now, I don't feel like I have the objective eyes to talk about this stuff, except for like this, right? I wouldn't necessarily actively practice a case like that for that exact reason. But
Well, as we look at how currently the U.S. Supreme Court seems to be mired in ethics problems, this idea of justices self-policing their ethics feels problematic to me.
I completely agree with
Yeah.
that. I
Okay.
completely agree that, you know, we've got this, it's an old, long-standing idea of who watches the watchers, right? The courts are ultimately our non-political branch of government, or are supposed to be.
But they're clearly, it doesn't seem like they're acting that way. And that judge, for a BYU grad to be so vociferous out of the gate, badgering Huntsman's attorney, that just feels conspicuously biased, you know.
It's the other thing I guess I'd hint at, aside from potential bias, and again, you know, we're not saying one way or the other, but the other thing I'd hint at is that a case is really to be decided on the facts that are in the record. And when you have such an extensive knowledge of facts outside of the record, that can pose its own issue that doesn't have to do with the question of bias.
Yeah, that's a good point. Okay, a big chunk of the early discussion was around the autonomy doctrine, about whether it's a violation, I think, of the First Amendment if judges are trying to interpret what tithing is and what it isn't. Anything you want to say about autonomy doctrine, First Amendment, who defines tithing, who shouldn't define tithing, and what this question of whether judges should be policing how the church does and doesn't define doctrines like tithing?
Yeah. There was one female judge on the panel who was asking a lot of questions that I felt like really got to the heart of the matter. She was asking questions about a church, a potential other hypothetical church. And for people who've never watched an oral argument before, these types of hypotheticals aren't just a huge part of oral arguments. They're a huge part of the legal field as a whole. Like law school is like one 3-year long hellacious experience in thinking through all these different hypotheticals, because that's how we deal with the law. Is we take a rule, we take a party saying this is the rule that should apply in this case, judge, and then we take it to its logical conclusion, sometimes even to the most ridiculous levels, to figure out exactly what they're actually arguing, or see the long-term effects of that. That's very common in the legal field. And the series of questions that I'm referencing, they were actually of the church's attorney. So this female judge was asking a lot of questions about a church potentially soliciting donations for a specific purpose, and then basically going back on that purpose. The church's attorney's response basically was that tithing is a commandment. Tithing is an inherently religious. The way I was at least understanding his comments is that tithing is an inherently religious thing that would then basically be protected by the First Amendment. And so to go back to this church autonomy doctrine, which we talked about on Monday's stream, the church autonomy doctrine has basically evolved to say that the secular courts cannot question a church's or a religion's religious decisions. And so I can understand why the church is making that argument. I think I tend to take the view that there was no real differentiating factor between the judge's hypotheticals that she was asking about and the facts, at least as Huntsman is entitled to have them interpreted, of this case. Because what he's saying is the church has this ongoing solicitation to support its mission through its practice of tithing. Whether they view it as a commandment or not, that's the First Amendment question to me. But what he's saying, and Huntsman's attorney hit this right at the end too, he said, the church added its own conditions with Hinckley's statements. And so that's where he's saying this is not a First Amendment case. One other reminder I'd give the viewers is that while the church is arguing that this is a First Amendment case, basically that it's barred by the church autonomy doctrine and the First Amendment, none of the 4 judges, federal judges who have heard this case previously have agreed with that position.
Okay. All right. So there were it was interesting to me that at one point the attorney for the church gave as a justification for his position that a church could always change its doctrine later, and that's one reason why judges shouldn't intervene in policing statements by church leaders, is because church leaders reserve the right to change doctrine later. Did you find that interesting at all?
I did think that was very attorney for the church in that case said something like, well, how can we be expected to know what happened 200 years ago? And I thought, like, don't you represent the organization that claims these things actually happened? It was a similar type of like weird argument to me, that particular comment that the church's attorney made.
I mean, in the real world, of course, both all churches and the Mormon church changed their doctrine over time. So of course a lawyer is gonna argue in the real world, and not try and argue in a silly world where God is the same yesterday, today, and forever. Because clearly, if any God isn't the same yesterday, today, and forever, it's the Mormon God.
Yeah, and from a First Amendment perspective, I definitely would recognize and concede that churches have the right to change their doctrine as they see fit. Now, and then people can make their own decisions on whether they want to stand with that organization or not based on how they change and shift, right? But one of the things I think that is a little problematic about what he said is that if we're looking at this case as a typical organization that's asked you for money and you've given money under certain conditions, he's basically saying it's like the Darth Vader thing in Empire Strikes Back, right? Like, I'm altering the deal, pray I don't alter it further. Like that's basically what he's saying, is that the church can't be held to any conditions because its doctrine can change, and because tithing is a doctrine. That's where their case is really muddled to me. I couldn't understand where their we just didn't defraud people case ended and where their First Amendment case began. It felt like, and this comes back again to my comments about the case we heard on Monday, it feels like the church has such an expansive view of the First Amendment that it's really difficult to it's really difficult to even understand their position.
There was a whole series of threads or discussions around who speaks for the church. It seems like the attorney for the church and a couple of the justices just thought it was obvious that only one single person can speak for the church, and that's the prophet at the time. That feels like a ridiculous argument to me. If you just use the example of a corporation, nobody would argue that only a CEO for a multinational corporation can speak for the corporation. There are literally PR people that speak for corporations, or the corporation can issue statements, or there can be other executives or officers that can speak for the organization. So I just was frustrated that idea that only a single person, the leader, can ever speak for the organization, that just seemed really silly to me. What'd you think, Kolby?
I thought that argument was incredibly silly because, again, if we go back to the church autonomy doctrine and what we talked about, the general exception from the church autonomy doctrine, if the theory you're suing a church on is a theory that you could sue any other institution on, then the church autonomy doctrine generally isn't applicable and the First Amendment isn't implicated. And how you determine who's speaking for an organization, regardless of whether it's a church or any other organization, is just a well-settled. I mean, I'm not saying it's not complicated to get to the bottom of it, but we generally know when someone's speaking for an organization, like, are they employee of that organization? Are they speaking at some official function on behalf of the organization? That line of questioning was very weird to me. It seemed like the church's attorney was hoping to get the judges to buy this theory that who can speak for the church is a religious decision, again, which then implicates the First Amendment. And that to me would be patently ridiculous, because that means that a church gets the unquestionable right to determine who speaks for it and who can bind it. There was one of the judges, I think maybe it was the Judge Smith, asked a question. Well, he characterized statements that were made at Ensign Peak as being like some random member. He said something to that effect. In the live stream, I commented on it at the time. And that is just so not even close to the reality here. Like, Ensign Peak, Roger Clark was the president of Ensign Peak and reported like directly to the first presidency in the presiding bishopric. So to say that was just like some random member, even like say that was some random bishop that made some statement, I just think that argument is ridiculous when you're dealing with the statements that we're dealing with. And we'll go through them in just a second. One was made by President Hinckley. One was made by the presiding bishop at the time, which the presiding bishopric's assignment is literally the physical and financial needs of the church, at least at the time before they did the corporate reorganization. One was made in Deseret News, the church's owned newspaper. One was made by a church PR spokesman at a church organized press conference, and the other was in the Ensign. So to hold out that those aren't like official statements of the church, I think is patently ridiculous.
Do you want to go to that slide and or do you want to just jump to the slides and finish whatever parts you think are really important to discuss?
I do, because going back to our First Amendment question, if you'll go to the next slide, this is actually just a little interesting tidbit that I found that viewers might find interesting. Is in significant appellate litigation like this, third parties with some interest in a case can file what's known as an amicus curiae brief. It's just Latin. Lawyers use fancy Latin terms all the time so that we can charge you a bunch of money when you have to talk to us. That's literally why we do it. Amicus curiae just means friend of the court. And so you can file a motion if you're a third party with sufficient interest and basically say, hey court, I want to enter into this as an amicus curiae and provide you with a brief and provide you with an argument. In fact, in Monday's stream, one of the amicus curiae was even allowed to argue on behalf of the church. So sometimes in rare cases that can even happen. These arguments often present, that party's position for the court from a public policy perspective, or give their perspective on the unsettled question of law that the case is about. And I want to start by saying, there's nothing untoward about amicus curiae briefs. I've participated as a third party in appeals, and I am in the middle of cases right now that have amicus curiae, and there's nothing untoward necessarily about that. But in this particular case, I found this a particular interesting tidbit. The church was joined in its position by a bunch of other religious groups and by the Becket Fund for Religious Liberty. Its brief was filed by its attorney, Eric S. Baxter. The whole idea of this, right, is that, hey, here's this other interested party that isn't us that's interested in this case. And so sometimes the parties may even reference amicus curiae arguments. If you'll go to the next slide, we can talk about this amicus. We can talk about Eric Baxter, because I think this part is very interesting. So 2 years ago, this same individual, Eric S. Baxter, was called to be an Area Authority 70 at the 2022 General Conference. And just to make sure that it's the same individual, here is from the church's website on the article when he was called. So you can see right there, Eric Baxter, Senior Counsel, the Becket Fund for Religious Liberty. So I just thought it was funny that, the idea of amicus curiae briefs is, here's this additional perspective, but at the same time, this really isn't an additional perspective. This is literally a general authority of the church who filed on behalf of the church's position. And it's worth noting, oh, sorry, go ahead.
That's gross. Keep going.
Yeah, it's weird. It's like pretending like you've got a friend that's supporting you, but it's just you again, right? And so it's also worth noting that the Beckett's position, and the Becket Fund's position, is that the First Amendment means that there's simply no line that a religion can cross, because any dispute over tithing is an inherently religious claim. And I know that the church's attorney said several times that that wasn't the church's position, but it felt like it was the church's position to me, because their position got so muddled between we didn't do it versus you can't even ask us if we did it because we're a religion. And I guess if I can get on my soapbox for just a minute, one of the reasons I wanted to draw attention to this, because I'm sure Eric Baxter is a great attorney and probably truly believes in the position he took in the brief. So I'm not saying that he did anything untoward by this. I just think it's weird. But one of the reasons I guess I wanted to talk about this is one of the biggest reasons to me that this case matters. This case is about way more than just tithing. It's really about where the First Amendment's limits are. And, as we've looked over the course of the last year, and we've had a lot of questions about the direction that the country is headed, and whether, it should be an explicitly, there are some that take the view that the country should be an explicitly Christian nationalist nation, for example. And those people are likely doing that because they take the same view of the First Amendment that the Becket Fund's brief filed by Eric Baxter takes. They're taking this view that religions get to define and pick and choose how they participate in society, and that they can be exempt from civil laws that any normal organization would otherwise be accountable for. And that's one of the things that really bothers me about this case. And it sounds weird, because I'm not saying that, the principle doesn't matter. I'm not saying that the money doesn't matter. I know there are so many people that are in such worse off financial positions because of the sacrifices they made to tithing. And I feel like it was insanely unethical for the way the church dishonored those sacrifices of the widow's mite. But really, to me, the reason I care most about this case, it's not because I'm an ex-Mormon, it's not because I'm a lawyer, it's because it really has to do with the fabric of our society and whether the First Amendment means that religions just get to call the shots on so many things. I mean, to basically say that we can say whatever we want and we can't defraud you, I just think that is a really difficult position for our society to recover from. Am I soapboxing too much, John?
No, that's great. That's important. Thanks for sharing.
Yeah, and I think it's why this case matters. And just so people can see, this is the outline of, if you'll pull that slide up one more time, this is the outline of the Becket Fund's argument right from its own brief that I pulled from their own website, right? So you can see it right there. The church autonomy doctrine bars courts from scrutinizing internal religious decisions. I don't have any problem with that. That's a correct statement of the law. It's the second one that's the problem. Any tithing dispute is inherently religious, because tithing itself is inherently religious, and decisions about expending tithes inherently involve inspiration and revelation. And again, to come back to the exchange that one of the female judges had with the church's attorney, she was really highlighting this element. And I think that's what the case will ultimately turn on, is that question right there, is, are all tithing disputes inherently religious disputes? I would be very surprised if the Ninth Circuit says there's no limit because of the First Amendment.
And it seemed like at least one or two of the justices were saying, which I think can be true, probably is mostly true, that when a faithful, devout Orthodox Mormon pays their tithing, they trust the church to do whatever the church wants to do with it. So I think there's some validity to that fact. I do think that most faithful Mormons who pay tithing don't really think about how the church uses the money, and would likely say, if asked, the church can do with this whatever they want. What I heard as the rebuttal to that is, if the church proactively tells people money is or isn't going to be used in a certain way, and then they violate their own pronouncements, that's when fraud enters the picture. Is that right?
Yeah, that's exactly right. And Huntsman's attorney was actually asked a question about that potential slippery slope. You'll see arguments like this in significant appellate litigation, where one judge or justice might ask, but if we allow your client to do this, isn't it going to open waves of lawsuits of people bringing claims against disaffected members bringing claims against their former churches? And Huntsman's attorney absolutely knocked it out of the park. He explained, the slippery slope here is just holding religions to doing what they said they would do. I loved that answer.
Yeah. And it looked like there was at least one judge that I think gave indications that he was Jewish, was basically fearing that synagogues and other Christian churches, etc., would again be faced with a wave of disaffected members who just wanted their money back because they no longer believed. And so they would, by any means necessary, try to claw back the tithing that they paid. Even if they left for religious reasons, they would try and use any type of justification they could to go gambling in Vegas with the money that they clawed back from. Wasn't it interesting that the church lawyer, as his hypothetical, said that the disaffected religious people would go to Vegas to gamble their money away?
Yeah, I thought that was hilarious. In the comments, I said, he's characterizing that as the wicked go to Vegas, but the righteous say, let's go shopping.
I love it. All right. Do you want to go to other slides?
I think before we go to the other slides, one last thing I wanted to do, just to give people a preview of what's likely to happen. Like I said, the matter's taken under advisement. It'll probably be some months. It may even be next year before we see a decision from the panel on this. The bottom line is that once that decision is made, if it's in Huntsman's favor, the church may appeal that case up to the federal Supreme Court of the United States through a process known as writ of certiorari, basically where you ask the court for permission to appeal. And whether the court would hear the case is entirely up to the federal SCOTUS. Or if it's in Huntsman's favor, then it goes back down again to the trial court. It does not mean if Huntsman gets a favorable decision, the church is found guilty of fraud, It means that Huntsman gets the opportunity to offer his case. And so with that, I thought it'd be fun for us to
really quickly.
Yeah.
My prediction, once our Supreme Court became 6-3, kind of super conservative, religious protecting as the 6, and more liberal, let's just say secular, representing the 3, it made me feel like this case was dead, because even if this circuit court were to rule in favor of Huntsman, certainly the church would appeal it. Certainly it would go to the U.S. Supreme Court, and they're so transparently conservative and religiously motivated that this case would die at the Supreme Court, because the Supreme Court and whatever connections Thomas or others had with their religious alliances, with Oaks, with the religious freedom, and all the other conservative religions that would cry foul out of concern for the implications for this case. The Supreme Court's going to take this case on appeal and defeat it. That's my biggest concern, and that's what I would predict would be the fate of this case, even if the justices ruled in Huntsman's favor. Any response to that?
Yeah, I always hate to be a downer and bring up the 6-3 majority we have at the current SCOTUS. The other thing I guess I'd highlight, I agree with everything you just said, John, that I don't want to say that I absolutely know what the current makeup of the Supreme Court would do with a case like this, because they have surprised me in certain matters. They have also disappointed me in a lot more. At the same time, one of the other, I guess, previews I will give people of what we'll likely see is it's just a matter of fact that the Ninth Circuit gets reversed by the federal Supreme Court a long time, and that's before. They often take some of the more aggressive, what people would call, quote unquote, liberal positions that sometimes get reversed. So that's another reality.
You're saying that this Ninth Circuit Court is notoriously liberal and that they're frequently overturned by the Supreme Court. Is that what you're saying?
Yeah, that's a reality.
Okay.
Yes.
All right.
Yeah.
That's good to know. Okay. Where were you going next, Kolby?
Well, I guess really what I wanted to do is, since we heard so much about these different statements, I thought it would be good to actually go through the statements so that we have a record of the 5 statements that Huntsman alleged were fraudulent. People can make up their own mind, and I'd love to get your thoughts on each and every one of them. So the first one was that Hinckley's statement from April 2003. One thing I'd offer, since the church's attorney said, the way he painted it and the way he was talking about this statement is almost like Hinckley said something and then he added a little extra on. This statement was made in general conference. And we just know, as a matter of fact, that statements made in general conference, like general conference addresses, are vetted by correlation, that they have to go through a translation process that starts weeks, if not months, in advance of general conference. So this idea that he was likely speaking off the cuff, I think is, to overuse a phrase I use too much, patently ridiculous. This statement would have been vetted. And as far as Hinckley's professional background, as far as I remember, John, he was in media relations. So this is not an unsophisticated person that's making this statement at the time. I think that context is very important. And I think the way the church's attorney attempted to frame it was pretty disingenuous.
Yeah.
But here's the statement from the April 2003. And this is the portion that the previous panel decision focused on. So this is the portion I pulled. Hinckley said, "We feel we have a compelling responsibility to protect the environment of the Salt Lake Temple. The property needs very extensive and expensive renovation. We have felt it imperative to do something to revitalize this area. But I wish to give the entire church the assurance that tithing funds have not and will not be used to acquire this property, nor will they be used in developing it for commercial purposes. Funds for this have come and will come from those commercial entities owned by the church. These resources, together with the earnings of invested reserve funds, will accommodate this program." And the paragraph there, the paragraph break, I want to be really clear that I went to the church's website and pulled their version, because that's where they put the paragraph break. And so this is the biggest statement, I think, which this case turns upon. And again, we talked about, from a legal perspective, Mr. Huntsman is entitled to every favorable inference of fact here. So I wanted to just kind of talk about how you would read this statement, John, because the way I read it is you have Hinckley giving clear, unequivocal statement. The tithing funds have not and will not be used to acquire this property. He then mentions funds coming from commercial entities. And then it's this use of the term invested reserve funds that we now know today meant invested reserve tithing funds. And that's where the church's attorney was arguing about these different buckets and saying like, well, we were really clear about these different buckets. It's worth noting that his statement that it was really clear what Hinckley was talking about, that's only if you kept in mind statements that President Hinckley had made 12 and 8 years before, where he talked about how the church's finances work. That talk those earlier talks weren't referenced in Hinckley's 2003 comments. They weren't cited in the general conference, like the printed version of the talk, as far as I'm aware. And so what do you think? Is it reasonable to feel like someone could hear what Hinckley said and walk away with the impression that no tithing funds, interest or principal, would be used to purchase City Creek?
No, I think it's ridiculous. And I, as a member who was, still faithful at the time the statement was made, there's no way I would have had any knowledge of prior statements. There's no way I could have invoked them to contextualize this statement from Hinckley. When Hinckley made this statement, I took it at face value and I believed it. And it's a disingenuous argument, but I also wonder if it's an effective one. If basically what they're doing is introducing other concepts that then effectively cloud the issue and give justices that want to rule in favor of the church and other religions, gives them the room or the justifications that they need to make the ruling that they want to make. So yes, it's disingenuous. No, it's not realistic. But also I worry that yes, it's an effective way to cloud the issue. What do you think?
No, I completely agree with you. I think when we look at the statement, if I'm just looking at the statement and I'm asking myself, do I think President Hinckley had some intent to mislead people? The truth is, I do. I think making such a broad, unequivocal statement about how no tithing funds would be used, talking about commercial interests and funds coming from those commercial interests, and then talking about invested reserve funds, I think a reasonable person is going to hear or read that statement and think that invested reserve funds, because he was just talking about the church's commercial entities and interests, he's talking about invested reserve funds from the commercial entities and interests, not invested reserve tithing funds. And that's why I cut that paragraph break the way the church did, because normally a paragraph break, and it may seem like I'm getting too semantical and weirdly nerdy with it, but I promise this is how legal cases are made. Like, this type of stuff matters. I've had cases that turned upon the placement of a comma. That's literally, when you're dealing with legally operative language, how technical this can get sometimes. And that's where I think, the church itself, in the way it's printed Hinckley's statement and is still on their website today, having a paragraph break there, I think it conveys that there's a break of information. And that.
Yeah. Yeah. And I'll just say Hinckley would never have made the statement if he didn't feel like there was rumblings of concern, or if he weren't concerned that members would be concerned about tithing money being used to build a commercial shopping mall. So the fact that he made the statement at all shows that, number one, Hinckley knew that members would have been concerned or were concerned. And then secondly, the fact that he was so specific in his answer shows his intent, which was to put the members' minds at ease that what they would otherwise have a problem with, they shouldn't be concerned about.
Yeah, that's 100% true. And we know that, not just because it's reasonable to assume that. The sentence right before the sentences that we looked at starts with him saying, now I want to turn some attention to some matter that's received attention in the local press. And that context is very important for people to understand. I even remember as a teenager how many faithful members were asking questions and voicing concerns about this. And so people need to recognize that context, I think, is very important. I also would draw attention to the fact that we're talking about the church making 5 statements about this. When was the last time you remember the church making 5 statements about like some social or contemporary issue ever. Like, think about how it was national news that they made one statement about Tim Ballard, or they made two statements about the Arizona Bisbee sex abuse case. For them to make 5 statements, I think really helps people understand the context that they were trying to reassure members that they weren't using tithing funds. And that's why, even though I know I can't get inside Hinckley's mind, I really do think that he had an intent to mislead people. I don't think he would have viewed it that way, though. I think people who reach that senior level of leadership in the church think that they're justified in doing things for the church, and they really believe that it's for people's ultimate good.
Oh yeah. The members will get confused. They'll think we're doing something untoward or dishonest. So let's just make a statement that puts their mind at ease, because clearly we're doing ethical things. Clearly, there are technically reserved funds that are going to be used. Okay, maybe we commingle all the funds, but we've made enough interest in our investments to cover this. So whether or not actual tithing got used, clearly, as I think came up in this hearing, just in that year, there was enough extra money made that would have covered this. So the members need not worry. We're doing things right.
Yeah, and we heard very similar arguments even from the church's attorney, right? Like today, they're still making the same argument. So the next statement was a little bit later in October 2003. And again, this was made by the presiding bishop at the time. I think it was David H. Burton. I should have had his name there, but again, if people don't understand, the role of the presiding bishop is literally to preside over the financial and temporal aspects of the church. That's what their job is.
He's the CFO. He's absolutely the CFO of the church.
Exactly.
Yeah.
And so, if we look at,
you have to ask yourself, if a CFO makes a public statement at a press conference, is he qualified to speak for that corporation or not? That's what I would ask people to consider.
Yeah, and I think to find that he's not is ridiculous, because it was at a church-run press conference.
Yeah.
He's an employee. He's a full-time employee of the church.
Yeah.
He's in a role that's literally described in Mormon scripture. Like, that's the role he's serving in, as presiding bishop. And his statement in October 2003 is, so he was asked specifically about funding for City Creek and said, none of this money comes from the tithing of our faithful members. This is not how we use tithing funds. And I think it's slightly different than Hinckley's statement. In some ways, it's even less favorable, because there's no hedging, there's no mention of this invested reserve funds, and the use of the language like comes from, I think, kind of blows the distinction that the church keeps trying to paint between principle and interest entirely apart. It's much more consistent with the way David Nielsen has said they treated things behind the scenes, that it was all just commingled into one big account. What do you think about that, John?
I mean, yeah, I think the statement is even more condemning. But again, by introducing this question of who speaks for the church and basically characterizing it as if any Tom, Dick, or Harry low-level person just makes some statement to the members, it's not official. Then they go back to its doctrine. It's the doctrine that matters. Only the prophet can determine what's doctrine. And so the prophet is tithing as a doctrinal thing, and members, pay based on their belief in the doctrine. I just think they're mounting an effective response for any judge that wants to err on the side of religious freedom and First Amendment kind of things, unfortunately.
Yeah, and even though, I have problems with taking the First Amendment way too far, I actually agree that churches should have the right to control their internal governance, their doctrine, their policies inside their walls. I think that's what makes this case so different, is that it went outside of that. It got close enough to fraud from a secular point of view that I just don't see how to characterize it as doctrine. But you're right, there are going to be people who fall on a different side of that line. This is one of the reasons that I'm a big fan of following this case.
I did like Huntsman's attorney's continued return to the word secular. He referenced accounting principles. He even sort of at one point referenced like an elementary school kid could understand one pile versus another pile. Like, he really did his best to keep returning the judge's mind to accounting principles, to, math. It's just a question of whether that's going to hold sway, I guess. But
Yeah,
of course,
entirely.
we all know what we think. Should we go to the next statement real quick?
Yep. So the next one was in December 2006, printed in the Ensign, which, again, to hold this out as not being an official statement of the church, like, then at what point, what is?
It's ridiculous. Yeah.
Yeah. Like, this was literally
Another-
something.
Another example of dishonesty on the part of the church's attorney, to say that a presiding bishopric in a public statement, or the Ensign, the church's official magazine, to say those statements aren't official, totally dishonest. I'll go ahead and read this next statement. It's from the Ensign, December 2006, and it says, quote, "The church first announced 3 years ago it was planning to redevelop the downtown area to energize the economy of the city that houses its headquarters and to bolster the area near Temple Square." And then here's the statement: "No tithing funds will be used in the redevelopment." This is Ensign, December 2006. And Kolby, let's just see if you're.
Is it better now?
It's better now, yeah.
Okay, perfect. I had to. We win as long as my AirPods will last. So that's
You
why.
sound great. You still sound great.
Okay, perfect. Yeah, and I have nothing really more to add on this one aside from just note that of the three statements we've looked at so far, it's only the first one that has any hedging at all, that has any of this distinction that the church is trying to get people to buy off on, getting the judges to buy off on.
And
They don't
these
see
come
anything
later.
about-
These come
What's that?
later, right? These come later. So in some sense, you could argue that they overrule the previous statement.
Exactly right, John.
Yeah.
And I mean, there it's just so explicit. No tithing funds will be used in the development, in the redevelopment.
Yeah.
You know?
Yeah.
Why is it? This is the thing I just wish I could ask believing are strongly carrying the church's water on this. What is so wrong with holding them to what they said? They said that they wouldn't use tithing funds in it. They did.
Yeah.
That's what David experienced. He literally, we read the quote before the oral arguments. He asked Roger Clark, "Hey, we represented to people that we weren't going to use tithing funds in this. Why are we using tithing funds in this?" And all that Roger Clark basically responded was how important it was to keep this confidential and keep it secret, and that people wouldn't be able to find it out. Again, I'm not saying that these people are like mustache twirling villains, but that's just a completely different level of ethics, ironically, than the church taught me. It taught me to be honest. It taught me to do the right thing and let the consequences follow. What is so wrong with holding them to what they said? That's not a violation of religious freedom. It's just holding them to what they said.
Yeah. I thought it was weird that the judge said, "Do you have any other evidence other than what Nielsen claims happened at Ensign Peak?" And of course the church doesn't share anything. All they did was file a statement. So how could there be any other evidence? And then of course that's the whole reason for a trial, and the whole reason for discovery is to be able to have the church provide the evidence. So it seemed a little weird that the justice was saying, "What other evidence do you have?" I think it's a miracle that we have the evidence that we do have, thanks to the courage of David Nielsen.
Yeah, and one of the things I wondered if this is where the judge's mind was going with that question was there's this process in the law known as like judicial notice, which is that there's basically some facts that are uncontestable, right? Like the fact that a certain city is in Idaho. That's just a matter of fact that you don't have to find facts on. A judge can say, "Yep, I'm going to just take notice of the fact that that's reality," right? I'm wondering if the judge was attempting to get Huntsman's attorney to reference the SEC order and the church's settlement with the SEC, because she was asking specifically about the seed money for Ensign Peak in 1997, if you remember. And that basically has been adjudicated and was admitted by the church in the SEC order. Now, the problem for Huntsman's attorney is that happened after the record for this case would have been settled. And so I'm wondering if she was trying to get him to say, there's nothing else in the record because we're not at that point of this case yet, but we do know of these additional facts that have basically been adjudicated by a federal administrative agency. It's, again, this is the difficulty with trying to read the tea leaves behind these questions, but that's where my mind started to go, is it's almost uncontestable at this point on the church's perspective that the seed money for Ensign Peak came from tithing funds because they've admitted it in a stipulated order where they paid $5 million with this federal regulatory agency.
Yeah, that's a good point. All right. Well, the final statement, I don't think we need to beat a dead horse. The final statement was from Keith McMullen, head of church-affiliated Deseret Management, and he used the term, "Not one penny of tithing goes to the church's for-profit endeavors." Specifically, the church has said no tithing went towards City Creek. So I think we've made that point. Those are the statements. Can I ask you a few more questions, Kolby?
Of course you can.
Okay. So when the church's attorney got up, he basically said there's two problems with Huntsman's case. One is that there's no misrepresentation because Hinckley acknowledged the three buckets and publicly stated that the financing would come from two of the buckets, not a third. And then the second one was that that the church's autonomy doctrine, the autonomy doctrine in the First Amendment, just protect the church and let the church do whatever it wants. Anything you want to say about those two arguments other than what we've already said?
Yeah. I mean, I don't agree with his position, but I actually think the church's attorney is representing the best interests of his client and did a good job of explaining, we just don't feel like we frauded anyone. If I was representing the church, that's the argument I would want to make. I think the problem I have with that argument, as we've already talked about, is that the only real way that the church has made that argument, and again, I'm not just saying this myself, this is from the panel's first decision in this very case. The only way that that's true is if people had in mind these separate statements that Hinckley made 12 and 8 years before that. And I just think expecting people to have tracked so closely something like that is expecting too much. Why shouldn't the onus be on Hinckley and the church to have just been clear? And again, to come back to one of your recurring talking points, which I completely agree with, John, why is it so problematic to just require the church to have real informed consent? Tell people, and that's the funny thing, is if the church wanted to say, we want to protect, it's one of our religious positions that we want to protect this downtown Salt Lake area. We feel like it's justified in using the return on tithing funds. I actually don't think most members would have had a problem, and there wouldn't be any case that exists here. I don't understand where this parade of horribles is coming from at just holding them to what they said.
So what would have needed to be said or not said for the church to not be in the pickle that it's in right now? What would have Hinckley or the Ensign or McMullen or Burton, what should they or should they not have said to make this problem go away?
Well, if Hinckley in that 2003 statement had said, instead of invested reserve funds, after just immediately talking about the church's commercial interests, if he had said invested reserve tithing funds, I think that there would be absolutely no case here, because then it's absolutely clear what he's talking about. But the reality is, we didn't know in 2003 that the church was investing reserve tithing funds into Ensign Peak. That was such a secretive thing that there's like this famous story that even like when Boyd K. Packer tried to get additional details on and he was acting president of the Quorum of the 12, that even he wasn't allowed to get details on Ensign Peak's total amount of assets. And so that's the problem. Like, that's the reason that Hinckley, in my mind, that's the reason that I feel very confident in saying that Hinckley had some level of intent to deceive people, because we already know he was. Because we already know that the creation of Ensign Peak was hidden from members on purpose. It was right there in that statement from Roger Clark that we read at the beginning of this stream that David Nielsen put into evidence in this matter, and Roger Clark entered a subsequent declaration or affidavit and did not contend that he didn't say that. And ultimately, the facts will have to be determined by a jury, but that to me says volumes.
Yeah. I mean, it seems like what should have been said is, the church brings in tithing. No tithing was used, but we do invest the tithing, and from the earnings off of tithing investments, that money is being used for Ensign Peak or for the mall and for Beneficial Life. And then the only other thing is they would need to have accounting practices that demonstrate that that's how the money is tracked and used, and that it was actually tracked and used in that way. The problem is religions don't have to report their finances. They have no financial transparency or disclosure. And so they're used to being able to do whatever they want and simply having some dude stand up at general conference once a year and saying, hey, everything is accounted for. All is well. These are not the droids you're looking for. And so I think the church probably just felt like, hey, whatever we do behind the scenes, it's none of your business because religions are protected. But that's what I think would have had to have happened for this all to be in the up and up.
No, I completely agree. And they just didn't want to go there. The irony is that, and this is the double bind that they were in, right? They're getting all these questions. They're in the news. They have to assure the members. So that's why they made this statement. And again, that's why I feel so confident in feeling like Hinckley had some level of intent to mislead people. I don't think he thought.
1,000%.
What's that?
1,000% he was misleading people.
Yeah.
Yeah, he knew better. Hinckley knew better, and he was choosing words that would mislead people. 100% that's true.
Yeah, and for folks that say, I just want to be mean to Hinckley because now I'm an ex-Mormon, like Hinckley was the prophet, like the first prophet I remember, even though, there were other prophets before that. But by the time I was old enough to really process who a prophet was and get attached to one, Hinckley was the one I was attached to. I still have messages that Hinckley taught and said that I think were great influences on my life. Like, I don't like thinking that this person that helped shape the person I am today had that intent. But at the same time, facts don't care about my feelings. And I don't see any other way to reconcile the facts. I really don't. And again, my opinion of how the facts will ultimately resolve or what Hinckley's intent doesn't matter here. In the legal proceeding that we just listened to, Mr. Huntsman is entitled to every favorable inference of fact. That means that we can assume bad intent on Hinckley's part, because then he gets a chance to offer that case to the jury. And the church also gets the chance to offer their case to the jury. And you know what? If the case goes back and ultimately goes to trial and the church is found by a jury to have not committed fraud, I'll be the first to report about it and talk about it. And because again, this comes back to the distinction we talked about a lot on Monday. What is moral and ethical and what is legal are completely different questions.
Yeah, please thank you. Totally true. And just want to remind everyone, please subscribe to this channel. Please like it. And we really appreciate that. That helps keep things going. Also want to thank our donors who donate to MormonStories.org that make all this possible. And any of you who want to become supporters of this content, please become a donor at MormonStories.org. Really quickly, Kolby, I think it's fair to ask, why did the church ever make any statement? If the church believes what their attorney was saying in today's hearing, which is that the prophet gets to decide what tithing is and members pay tithing as a matter of faith and they don't care how it's used, then why were those 5 statements ever made? Isn't that a fair question? If that's how things are, that prophet determines and members blindly pay, then why were 5 statements ever made? That came up in today's hearing, correct?
Yeah, and I think that's why we talked about the context. I wish we would have heard a little bit more about that, because that context, I think, is really important to understanding. The church doesn't make 5 statements over the course of just several years. It looks like they span the first 4 were over 4 years, and then the last one was in 2012. But so 4 statements in 4 years. Can you think of any social issue that the church has made 4 public statements about in the past 4 years? I think that I keep highlighting that because I think it really helps inform the context here. The church was probably getting a lot of pushback from believing members that wanted assurances that their money wasn't going, that their tithing money wasn't going to a shopping mall. And that turned out to be exactly what happened.
Yeah. Let me ask you about a couple other things really quickly, Kolby, and then I'll just ask your predictions on what's going to happen. Was it admitted in today's hearing that the church may have commingled funds? Did you hear that today? Kind of an admission of that?
Yes, and actually the writing declaration. So Paul Writing is the head of or at least was the head of the church's risk management division. We actually learned a little bit about him last year, if you remember, John, when there was reporting in the Associated Press on Chelsea Goodrich's sex abuse case against the Mormon Church, or at least potential case that she settled with the Mormon Church, because Paul Ritting was the attorney involved in that. So Paul Ritting, there were 2 declarations in this matter filed by the church before it was dismissed. One was by Roger Clark that just vindicated, or not vindicated, validated a bunch of documents. And the second was by Paul Riding. And Paul Riding affirmed in his declaration that funding for City Creek came exclusively from the invested reserve funds, which were originally created with tithing. And so that's I do think the church basically admitted to commingling, because that's just how they did things at Ensign Peak, because they just mixed everything into one big bucket.
Yeah. So I don't know if that will be noticed by the justices or if that will affect their decision. But that's a question that I think I and others have had. Secondly, was that contradicted? Was there a statement that said we have unrefuted testimony that only interest from reserves went to the mall? Did you hear that contradictory statement in today's hearing?
Well, I think what the church is hinting at there is they've basically tried to break this, create this distinction between tithing donations, which is like when it's coming into the church's coffers, and then and they're calling that the principal sometimes, and then the interest that they receive or the returns they receive on that ultimate investment. And I think that's actually one of the reasons, if I'm understanding the church's position correctly, I think that's another reason that I really just don't see their distinction that they're trying to create holding a lot of water, because that's basically saying that the members' donations to the church didn't go towards City Creek. Like, the members would obviously know that, right? If that's what they're trying to say tithing meant.
Yeah. Okay. A couple other things really quickly. Was the statement made at some point the church has not given any misrepresentations on this issue? And if so, I think you've already mentioned this. Is that contradicted by the SEC order?
I'll think about if it's contradicted by the SEC order for a second, but yes, so that was said. And again, the only way to take that view is if people, when they heard Hinckley's 2003 statement and they heard these other statements, had in mind these separate statements that Hinckley made in both 8 years before and 12 years before about how the church manages its finances, or if they had some, they had some insight into that the rest of us didn't. That's the premise of the church saying there was no misrepresentation, is that Hinckley's terms were clear if you had in mind these other statements. That's what they're trying to say. Now, as far as the SEC order goes, I don't know that it directly speaks to the facts that we're talking about here, but I think it definitely changes the tenor of the conversation, because when you've got a federal regulatory body like the SEC that imposes a penalty on a church, you just have to know how difficult that is from just a political position, from the privileges that religion enjoys under the First Amendment. That is really, really difficult to do. And again, that order was entered into as a stipulation with the church. So I think it does change things. How it will factor into this decision is interesting, because it came to light after the record was created in this matter. But I would expect it to be a huge game changer if the matter returns and goes back to the trial courts.
All right. The last one other thing I'll end with before we talk about your predictions. Did he suggest that David Nielsen's testimony was not particularly damning?
He did say that, yeah.
Any thoughts on that?
Yeah, and I think what he's saying, he's just begging the question, right? He's saying, well, if I'm right about everything else, then David Nielsen's testimony is not particularly damning. That's what he's saying, is like, if it's reasonable to expect people to have Hinckley's statements from 12 and 8 years prior in mind when he made that statement, what he said was clear, and it doesn't matter what Ensign Peak labeled the funds, basically. That's what he's trying to say.
Yeah. All right. Well, really quick, Kolby, you've been great on this. Everyone loves your commentary. Quick thoughts on the jurisdictional issue. Anything you wanted to say there about whether about James Huntsman's residency and the concerns the justices raised about whether he was a Utah resident? It seems like they were saying that on a website, James Huntsman's address was or in corporate filings was indicated as being in Utah, not California. Any thoughts on the residency question?
Yeah, it didn't get as much traction as I thought it would, because it's pretty irregular for them to put out a notice like that and ask about it. It happens from time to time. It's just usually not that big of a deal. I don't think the case will be dismissed on those jurisdictional grounds. I think if the court can, courts often try and take the easy way out and decide on the non-substantive parts. In fact, they're instructed to. There's this doctrine known as the doctrine of constitutional avoidance that actually requires courts to do that. But I don't see that happening. It sounds like from all the information that you knowing James, there was Mark Pugsley in the chat was saying James definitely lived in California at this time. That's going to be much more dispositive than some business form that was filed.
Okay. Yeah, and it seemed like the church's attorney admitted that they didn't think that the residential jurisdictional question was really a problem. Didn't they kind of admit that?
Yeah, well, what he was admitting was one of the judges was asking him, why didn't you, when he was deposed, ask additional questions about this so that we had a better record to understand whether the jurisdiction was proper? That's what he was answering. But the fact that there was only one question of it to the church's attorney and one question of it to Huntsman's attorney, I don't think that's how this case will ultimately resolve. I would be surprised.
Well, it seemed like the church's attorney got a lot more time than Huntsman's attorney. Was that your impression? And if so, why was that?
So it felt like that to me, but that wouldn't have been the scenario. So typically you have 30 minutes for oral argument on each side. And it's important to remember that Huntsman's attorney reserved 5 minutes of his time to get up on rebuttal. So that's customary, so that the party who's basically challenging the prior court action always goes first and last if they would like to. And so it probably is more just feeling. I think also the church, even though both attorneys got asked a lot of questions, I did feel like Huntsman's attorney got asked more questions. I didn't count 3 uninterrupted sentences he got out consecutively, but maybe I'm wrong there.
Yeah.
And so I think that probably made us feel like it was moving faster, but the clerk of the court would have been keeping time.
Were you able to do a count of how many justices seemed? I know you don't like to do this, and it's you said at the beginning it's too tricky, but if you had to guess a count of how many justices seem to be leaning for the church versus how many justices seem to be leaning for Huntsman, could you even make a count?
I really only felt like 2 of the judges all of their questions seemed to indicate that they favored the church's position. There were some that initially, when they were questioning Huntsman's attorney, I felt like, oh, that's a tough question for him to answer. But then they turn around and also asked tough questions of the church's attorney. And again, I couldn't get a count to answer your question more directly. But again, it's difficult to really even get a feel from the questions they ask, because oftentimes, so I worked for an appellate judge, and oftentimes he would ask the party that he sided with more going into the argument, the more difficult questions, because he wanted to vet their position and use it to build out distinctions and to head off some of those like slippery slope arguments. So all to say, it's really difficult to guess where a judge is leaning based on the questions they ask.
Yeah, my impression was that more judges were against Huntsman and for the church than were for Huntsman and against the church. But I agree, it's hard to know.
Part of that may be, though, that this is a very unprecedented case, right? Like a case like this it's national news for a reason, because it's a very big case for a church to be held to account for tithing fraud.
Yeah.
There's a reason that other churches are concerned and taking an interest in this case as amicus. And so all to say, it's not necessarily that they don't favor Huntsman's position, but Huntsman has the tougher battle. I mean, he lost at the district court level, right? And so he is asking ultimately this panel to overturn that district court decision and side with the panel that sided with him the first time around.
And this is the implications are so significant. If all of a sudden a major decision impacting all religions across the United States, allowing members to sue for tithing, were to be approved, the implications are significant. So I could see why there would be a high level of scrutiny, just because the judges would be on the receiving end of some serious grief by a lot of people if they opened the floodgates to lawsuits and U.S. churches were sued into oblivion by ex-members. I want to thank Scott Barrett for his super chat. He just said, just keep talking. Thanks, Scott. Scott also shared later I'm beginning to think that the Mormon church is the ultimate shell corporation, totally unaccountable. And I think, that is a concern that many of us have. Really quickly, Kolby, do you feel, I wanted to ask you whether you felt like Huntsman's attorney or the church's attorney did a better job, not which case, how do you want the ruling to be, not even, how you think I guess I want to hear which attorney you think did better for their client, and if you have opinion about, how you think the law stands given the discussions that were made. Does that make sense? Can you talk to both of those things?
Yeah, I can. First, I got distracted because my mom's in the live chat, and it's her birthday tomorrow.
Who's A. Reddish?
That's my mom.
Oh, hey, A. Reddish. She should be applauding you more than applauding me. But hi, Kolby's mom. Thanks for the super chat. And your son's awesome. You must be awesome if you helped raise Kolby. All right.
And happy birthday tomorrow, Mom.
Happy birthday, Kolby's mom.
And
go ahead, Kolby.
Okay. Can you remind me of your question? I'm sorry.
So first question is, based on the law, where do you see this case as being, based on the arguments and responses made, who's winning in terms of the law? And then which attorney do you think did better?
Okay, yeah, perfect. I thought both attorneys did a good job. And it's so difficult for me to set aside my bias because, man, not only do I want the church to get some comeuppance for its behavior, but I also, just as an attorney, really love rooting for the little guy. I think Huntsman's attorney did do a better job, and here's why. I think that anytime he had a tough question, I think he really stuck to the law, and he was very clear about his message. I felt like the church's attorney's message was a lot more muddled and difficult to understand. And it's just never fun to have to advance like a technical argument like, well, you don't even get to ask whether we committed fraud because of the First Amendment. That's not a fun argument to advance, or not necessarily a convincing argument to advance. Not as convincing as just like, hey, we didn't do fraud. And I understand he tried to advance both, but they were so muddled that I had difficulty sorting out which was which, to be completely honest. I feel like Huntsman's attorney, especially in that last 5-minute rebuttal, did an excellent job. It was like really, really clear statements of the law, really, really clear statements of where things are, where he's headed. He was able to head off, the parade of horribles, slippery slope argument that one of the judges asked him about. As far as who I think is more likely to win on the law, I think it's difficult to say because there's so many different areas that the judges ask questions about that are implicated by the case law on this. But I think, again, and I said this in connection with our discussion on the Gaddy case, if any case has a good chance of succeeding, it's this case. And it's because it's so narrowly tailored in scope to those 5 specific statements and the allegation that the church did exactly what it said it wasn't going to do. I think, again, not to necessarily dodge your question, but I think, again, one of the reasons that this matters is because even if the church wins in the worst grounds possible, which is the Ninth Circuit or SCOTUS saying the First Amendment means that churches can never be held to account for fraud, the reality of our system, guys, is that can change. That's the genius of the American system. Everything is subject to change. And so I'll come back to the comments I made on Monday, which is if it goes too far, there are corrective mechanisms, but it requires people to get informed and to take action and to demand better from their elected representatives. I think that's where I'll end.
All right. Well, so no predictions on how this case is gonna end.
I can predict that it'll be narrowly divided. I will definitely predict that if Huntsman prevails, that the church will seek writ of certiorari. That's textbook what they'll do. I would not be surprised if the Supreme Court of the United States granted certiorari in that case. So what I want to happen, John, and maybe this will be my prediction, what I want to happen is for the Ninth Circuit, it'll definitely be a divided panel, but what I want to happen is for the church to lose the issue today, and then I want it to go to SCOTUS, and we'll see what happens. I don't have a lot of hope that SCOTUS will do the right thing, but again, that's where we can keep we can keep our institutions and we can keep our civic institutions and our elected officials accountable because we can. That's the genius of the system. And so even a loss can get us talking about the realities of some of the extensions of what the church is arguing. To argue that they can just never be held to account for fraud because that's what the First Amendment means, that can't be the state of the law, guys. It just can't. We'll have to change that because that's dangerous. That's a slip towards theocracy that I just don't think we can stomach.
Love it. All right, really quickly.
Can I address this live? Oh, sorry. Go ahead.
Here's a really interesting comment. Scott Gill writes, can we talk about how Justice Smith is Senator Gordon Smith's brother, who I believe was a senator from Oregon, and that Justice Smith's father was chief of staff for Ezra Taft Benson when Benson was Secretary of Agriculture. And we know that Senator Gordon Smith, was in those Mormon leaks videos where he was basically, as a U.S. senator, meeting in front of the First Presidency of the Quorum of the 12, basically telling them that he would do their bidding and fight for whatever the church wanted, in the U.S. Senate. So that's interesting to know that background on that Judge Smith.
I don't know if that's true, but if that's true, that's mind-boggling to me. That someone who had a brother that made those statements.
Kolby, would Scott Gill lie? That's a joke. I'm joking. I don't know.
Can I address a comment as well?
Yeah, please.
Comment from Martinez.
Yeah. Okay, here it is.
Perfect. So I want to address this. Careful, Kolby. It says if everything is subject to change in our American system, then the same could be true for the church and its argument. That's entirely, completely different things, Jess. The Constitution literally begins, we the people of these United States. That's the origin of political power in the United States. We get to change it because it is subject to us. We are the government. The government answers to us. There's a difference. The church claims that it's a restoration of ancient truth or that it's God's one true truth. That's the difference, is anything is subject to change because that's the way our system was designed. That's the ingenious part of the American system that I wish more people would appreciate.
All right. A couple other final things. Star Beatles Queen asks, did James Huntsman attend this hearing? My understanding is that he did. I can't say that for sure, but that's my understanding. Wicked Smot says, thank you for the excellent coverage. And Josh Caldwell says, excited, Kolby, for your upcoming podcast in the works. Kolby, do you want to promote that really quick?
Sure. So in the next month or so, my wife and I are going to be launching it's going to be a YouTube series dedicated to increasing people's access to case law, understanding the legal system. We're going to call it Common Law Uncommonly Explained. And so in the future, look forward to that. Our first episode will actually be on what a common law system is and the famous 1803 case of Marbury versus Madison, which created the idea of judicial review and basically defined the role of the Supreme Court, and is still cited at both the federal Supreme Court level and state court level all the time in determining what the role of the judiciary actually is. It's one of the reasons I have such an appreciation for the hard work that judges do today.
Absolutely. All right. Well, Kolby Reddish, thank you so much for joining us today on Mormon Stories. It's always great to have you. You're the best.
Thanks, John. I appreciate it. And I appreciate everything you do. And I'd be remiss if I didn't say, and I've said this on other podcasts before, and I know you always get embarrassed when people say nice things about you, but you are a great person. You do a lot of important work in this space that people aren't even aware of. And I just like saying that. I'm glad that we've developed this friendship and glad that we got to discuss this today.
Likewise. Thanks, Kolby. Please come again. Say hi to Cam and hi to your mom, and hope you and your mom have a wonderful birthday for her.
Great. Thanks, John.
All right. Thank you all today for joining us on Mormon Stories. Thanks to Julia and Maven and Gerardo and Brooklyn, who all worked behind the scenes to make all this possible. Thanks to our donors that make this possible. We couldn't do it without you. Thanks to the super chats that were given today. Thanks to all the great comments. Thanks to James Huntsman for his courage to file this case. Thanks to David Nielsen for being a whistleblower. This case wouldn't happen without you two courageous men and friends. I also want to just remind everyone that we lose donors every month. And if we don't replace those donors with new ones, then our revenue drops, and then we have to drop services. So if you value this type of coverage, if you value this type of content, and you want to see it continue, the way to have it continue is to go to mormonstories.org, click on the donate button, become a monthly donor, and we'll keep providing this type of content to you. We love your feedback. You can share it. There's a feedback form at the new redesigned mormonstories.org website. You can provide feedback there, or you can email us at mormonstories@gmail.com. There's also a new application form if you or someone you know or love want to be a guest on Mormon Stories podcast. Please go to the application form on mormonstories.org, click on it, fill out the application. There's so many people we want to interview, people who returned home early from their missions, recently returned missionaries, people who have lost their faith recently, believers who want to tell us how they believe these days. We're doing stuff on infertility. We're always interested in mixed faith marriages. We're looking for superstar Mormons who lost their faith, former church leaders, blue blood Mormons, anyone who's worked for church headquarters or, CES, any whistleblowers that want to share, and grandparents, people who lost their faith as grandparents. Those are some examples of the types of people that we want. So if you want to be on the podcast, please fill out an application. And we'll end as we always end. Thanks for joining us today. Please be good to each other. Be kind to each other. We'll follow these developments of these cases as they develop. But we'll most importantly, we'll see you all again soon at another episode of Mormon Stories Podcast. Take care, everybody.